morning, everybody. Well, you'll have to switch on your mic, otherwise I won't hear you.
Morning, Mr. Chair.
Okay, all right. We deal with Mr. Gama's application for leave to cross-examine Mr. Todd. I did have a look at the supplementary affidavit yesterday. I'm not sure whether it should have been filed, but it does say that it was just to err on the side of caution. Yes, you may start.
Thank you, Mr. Chair. So, insofar as the application for condonation is concerned, I submit with respect at the outset that...
Yeah, you can take it that I don't have difficulty with condonation.
I'm indebted, Mr. Chairperson.
Yeah.
I will then proceed to deal with what I term to be the merits of the application. And at the outset, I wish to make reference to the opening statement of the legal team of the Commission, and in particular, paragraph 30 thereof, and I quote as follows: where the Commission is asked to interrogate an issue, the legal team will not presume a particular outcome. Witnesses may have different, even contradictory versions in relation to a particular factual allegation or set of facts. It is our function to explore all material and relevant versions, unquote. My emphasis, Chair, of course, being on the caption, the legal team will not presume a particular outcome. In the context of this application that serves before you, Mr. Chair, I advance the proposition, having regard to that paragraph, and in particular that caption of the legal team's opening statement. It certainly was envisaged that the approach taken by Mr. Todd in opposition to this application for him to be subjected to cross-examination is hardly an appropriate one. I say with respect that much could be said about the fact that the Commission's legal team seems to want to rely on the submissions by Mr. Todd in his answering affidavit. He says two, for purposes of my argument, fundamental things. Firstly, he says, I volunteered my testimony before the Commission. I'm a seasoned, experienced litigator. If I recall correctly, he says he became a partner of Bowman's attorneys way back in 1998. It's not a lay witness that we're dealing with, and by submitting that, I'm not conceding for one moment that he's an expert witness, albeit that he attempts to deliver expert testimony before this Commission. Much will be dealt with in that regard, if you permit, with respect, my application to cross.
I'll tell you what I'm really interested in.
As you please.
I'm very interested in whether there are any disputes of fact between matters dealt with by Mr. Todd, in respect of which he has personal knowledge, and matters that Mr. Gama wished to dispute or deny in terms of facts. So that is the one thing. The second thing, and that is not because it's less important than the first one, actually it might be more important. I need you to address me on why I should grant Mr. Gama leave to cross-examine, that is, if there are disputed facts between him and Mr. Todd, why I should grant him relief in circumstances where he says in his founding affidavit that whether or not he presents himself to give evidence will depend on the outcome of the application. In other words, he's not committing himself to giving evidence before the commission unequivocally and unconditionally, but says, depending on the outcome of the application, and I think where he says also, depending whether it's desirable, that's one of his last paragraphs, that's what he says, he may then make himself available to give evidence. Now, I would be disinclined to grant leave to any person who says, well, if you rule against me, I won't subject myself to the processes of the commission. In other words, I want to cross-examine other people, but I don't want to be questioned. So I would be disinclined to grant such a person leave. That's my understanding of what he says towards the end of his founding affidavit. What do you say about that?
Mr. Chair, I submit that there's that possible interpretation. If I might address the two questions posed to me by beginning with what Mr. Chair poses at the tail end.
Maybe just to be sure that you know what I'm talking about, I'm referring to paragraph 35 of his founding affidavit, and it reads, should it be necessary or desirable thereafter, and depending on the content and results of the cross-examination, I undertake to give evidence before the commission and to cooperate as best I can in order to advance the objectives of the commission. But that's how I've given you my understanding. You might say that's one way, but here is another way, but that's part of my concern.
I'm fully alive, Mr. Chair, to what is contained in that paragraph. So it wasn't necessary for me to consider it as it features in the papers, and I can immediately respond. Perhaps, to a certain extent, it is phrased regrettably ineloquently. That's my starting point. There is to be read into that caption nothing whatsoever which suggests that my testimony before this commission is dependent on whether in fact I'm granted leave to cross-examine. But I hasten to add this, Mr. Chair, and it is indeed so that my client has been preparing an opening statement, and I don't want to make a submission on which I'm contradicted at a later stage, and I do this purely so as to be cautious in my approach to what I submit to Mr. Chair. It is, in fact, correct that Mr. Gama wishes to cause the cross-examination of Mr. Todd because he believes, and to deal with Mr. Chair's first question, I'm going to refer and cite a perfect example of where he's accused by Mr. Todd of being a fraudster. There's a stark dispute of fact in relation to that allegation. It will, with respect, focus on the GNS contract and what transpired, particularly and in essence, during the disciplinary hearing of my client before Antrobus SC, who was the chairperson. To make such a statement in the context of joining him almost to a conspiracy, a common purpose, if you wish, with people like Kanye and Senamela, and to describe the trio as fraudsters should never have been condoned. In fact, if that wasn't an absolute allegation, then my learned friend, Mr. Myburgh, ought to have corrected it. I will refer in a moment to that, but I don't want to dwell on that for too long. I want to return to the second question, if you'll permit me, Mr. Chair. So, perhaps ineloquently phrased, but it is not conditional on. The rules don't permit for that, and I, as counsel, would not permit that situation. So, with respect, Mr. Chair, must please not interpret that there's a conditional undertaking to give evidence in these proceedings. My client is a compellable, competent witness, as is, by the way, Mr. Todd. He will comply with the processes, and we've already indicated, and there is an informal arrangement as to when he will take the stand, so to speak. So, if that answers the question, it is not conditional. I know I sound repetitive, but I want to make the position very clear. My client would not take that disrespectful stance towards Mr. Chairperson, and that's not his intention. So, I think what he's trying to perhaps illustrate is he would be better positioned to, during his evidence, refer to certain aspects, not necessarily contradictions per se, perhaps admissions that are elicited during the cross-examination of Mr. Todd, if you'll permit that, and it will permit him, as far as he sees it as a lay witness, to advance perhaps more eloquently and efficiently his testimony before this commission. Mr. Chair, if that then addresses the second aspect. So,
can I check this with you? Is the position that you are saying definitely there is no intention on his part to make his cooperation with the Commission and the giving of evidence that is supposed to do dependent on whether his application for leave to cross-examine is successful or not? That's not the intention, and that's not his position.
Absolutely not.
Okay.
So it would be, I repeat, it would be disrespectful of him to do so, and that's not his intention.
Okay, no, that's fine. And then I think the next thing is what the disputed facts are. You mentioned the issue about fraudster. Well, just deal with the issue of what are the disputed facts or are disputed allegations of fact between the two.
Mr. Chair, with respect, I'll address that issue, but before I do so, we have, not having been favored with a copy of the Commission's bundle, and I'm not pointing fingers, I'm simply saying I understand that to be protocol. So as to enable Mr. Chair to follow my reasoning and argument, we have prepared a bundle, and with Mr. Chair's leave, I would like to hand that up so that you can follow more easily. I don't have the page numbering in the Commission's bundle prepared for this application. So we haven't been able to cross-reference.
Yeah, no, I'm not sure that I would need it. I would simply look at his founding affidavit. I would look at Mr. Todd's response and the reply, because what the disputed facts are that cross-examination is supposed to resolve should appear from those affidavits. So I struggled a bit as I was reading them, but maybe there's something I didn't understand where the disputed facts are. Okay.
Thank you, Mr. Chair.
Yes.
So my submission with reference to this fraudster issue is to be found in the transcript, which is an annexure to our founding papers.
Start in the founding affidavit if you
This
don't
aspect,
mind.
this particular aspect is dealt with in an overarching way during. In other words, where we say we take issue with how he's presented his evidence, for instance, that our client is implicated. But it doesn't feature per se in the application. It's of an overarching nature.
Yeah, but I would be disinclined to grant leave, and then the whole thing gets expanded to issues that really were not made clear in the founding affidavit. Because, I mean, the Commission has serious constraints on time. If I grant leave, I want to be sure that it's in respect of clear issues that have been covered in the papers.
Very well, Mr. Chair. I'll then commence with a reference to paragraph 4. And the way I've prepared this is to have regard to the replying affidavit, in which we consider not only the founding affidavit by my client, but also the answering affidavit deposed by Mr. Todd, if you'll permit me. There's a cross-referencing, and I will...
Yes, but what I expect you to do is to start with the founding affidavit and say, here are the paragraphs where we raise disputed facts that will be resolved by cross-examination. Then to the extent that, and then go to the response or answering affidavit to say, this is what he says. And then if you need to go to the replying affidavit, you may go. But the founding affidavit is important as a starting point.
As you please, Mr. Chair. So, we might as well commence with paragraph. There's a reference to paragraphs 22 to 32. That is the founding affidavit on page 10. Where we say not only...
Okay, don't speak too far away from the mic, otherwise I won't hear you, and the record won't have... okay, you said 22 to...
At paragraph 22. Doesn't deal exactly with that first point in issue, but it says that he sensationalized, and he came before this commission with a motive to implicate him, and in certain respects implicate him falsely. It's a denial by our client. Our client says that there is no merit to this kind of an allegation. It places the entire context.
I'm sorry, the starting point must be, this is what Mr. Todd said in his evidence on his affidavit that I challenge.
Mr. Chair, I will then move on from that aspect.
Yeah, okay.
It proves a little challenging because it wasn't quite how I planned to present this application. But if we go to the very first aspect then.
Yeah.
Which is paragraph 23. Sorry, paragraph 22 of the founding affidavit. And it is referred to in paragraph 10 of Todd's affidavit, and then in paragraph 4 of the replying affidavit. What we say, in paragraph 2 per the founding affidavit, we say that the purpose of the testimony by Todd was to sensationalize matters when he recorded that our client had been copied in the email to which was attached a copy of the memorandum from Mr. Mtetwa, General Manager of Transnet Rail. There is a clear...
What did Mr. Todd say about that?
He says, Mr. Chair, he says, in para 22, one of his affidavit, Mr. Gama states that I sought to sensationalize matters by pointing out that he had been copied in an email which in turn attached a copy of a memorandum from Mr. Mtetwa. He then goes on, and he provides an exposition of why he says this is not sensationalism.
Yes, but I want to start,
on this.
I'm sorry, I want to start in your client's founding affidavit. What does he say in his founding affidavit, Mr. Todd said about that affidavit, that memo or email that he disputes? Because when I was reading the affidavit, I'll tell you what my challenge was. I struggled to understand whether the issue was that Mr. Gama was saying, Mr. Todd says, I wrote that memo or email, and I did not write it, or whether he was saying Mr. Todd accepts that the email was written by or was drafted by somebody else, but for me, and I just signed. So I think when he goes to his replying affidavit, he may be using the word created, Mr. Gama, to say, I did not create that memo or email. And I tried to look for the email. I couldn't find it immediately because I wanted to see whether this is a situation where the email on the face of it or memo came from him. It's got his name on, but he was simply saying somebody else created it. It's somebody else's ideas, but I just had to be under my name for whatever reason. Or whether he was saying, I was copied on it, and that's all that there is to it, my connection with it. So I was struggling. What is the position, as you understand it, about that memo or email?
Mr. Chair, Mr. Gama says he was not the author of that memorandum.
But let's start with what did Mr. Todd say about him and that email?
And that's just the point I want to advance before you. With respect, we shouldn't remove it out of context, because what we're saying is sensationalized, and sensationalized in this sense, that my client was there to influence certain committees, and in particular, the risk committee, where Mr. Mtetwa ultimately made a submission. We're not privy to what that submission was. So what is Mr. Todd doing? He's sensationalizing. But he doesn't know.
What did he say that you interpret as sensationalizing? What did he say about that email and Mr. Gama that is seen as sensationalizing?
His entire evidence, if you consider it in context with respect, is to suggest that my client had a hand in and was party to influencing the powers that be at board level, at committee level, and that my client was instrumental in that. Now, in the ordinary context, when one says he was copied in, it would suggest at best that the person copied in, if he had read and considered the contents and the body of the mail, would have acquired knowledge. But in this context, it's something very different. My client didn't have a hand in the creation of that memorandum, and in the ordinary course, and Mr. Todd ought to know this, protocol requires that memoranda are prepared and certain senior persons sign off. Okay. That's the context, Mr. Chair, and I want to encross.
Okay, I see that in paragraph 22.1, Mr. Gama says that Mr. Todd
I'm not
said,
following, sorry, Mr. Chair.
I'm sorry.
So I'm not following you up, I apologize.
Yes, okay, all right. No, I see that at paragraph 22.1 of Mr. Gama's founding affidavit, where he deals with the issue of this email, he says Mr. Todd said he was copied in the email. Yes. So in other words, that's what he says Mr. Gama said. Now, he confirms in the next sentence that he was copied. So that's common cause. Yes. And he says he was copied since at the time he occupied the position of Chief Executive Officer of Right Rail. There is thus nothing sinister in the fact that I had been copied. And then that's where he stops, other than that he says Mr. Todd sought to sensationalize matters. But they agreed that he was copied. He doesn't say what else Mr. Todd said on the basis of which he says Mr. Todd sought to sensationalize matters. In other words, he accuses Mr. Todd of seeking to sensationalize matters, but other than saying Mr. Todd said he was copied, he doesn't provide any basis for that criticism as I read this. Then he moves to another point. Okay. Is your understanding the same as well? It is the same.
Mr. Chair.
Yes.
It is with respect the same. Yes. However,
yes,
we're losing sight of context. That really is the nub of my client's complaint in this paragraph and the cause for him wanting to have Mr. Todd cross-examined. And we should never lose sight of the context.
Yes.
And it's exactly that context that prevailed throughout the various witness statements, 5 of them, 5 witness statements.
But that context should have been in the founding affidavit as well, isn't it? So that Mr. Todd could deal with it and the legal team could deal with it properly. To say this statement by Mr. Todd that I was copied in regard to this email must be seen in the following context. And then the context is set out. And to say, that's why we say he was seeking to sensationalize the matters. Yes.
I think in the commencement, and the fact that our client was served with not only Rule 3.3 notices and 10.6 notices, which required that he consider this evidence. And this is perhaps my answer to that. The fact that he was served with a Rule 3.3 notice in relation to the testimony of Mr. Todd, and I want to add this, in some instances, he was never given that prior period, what we term to be reasonable notice. That wasn't there. But certainly in the context of the 3.3 notice that says Todd's going to testify and is going to implicate you. In that context, we say, and that is to be found when we deal with these aspects at the commencement of his founding affidavit, that is the purpose with which Mr. Todd came to testify before this commission. And then we say, and then he proceeds to sensationalize. It's all with respect in the context of exactly that. One shouldn't lose sight of the context, which is at the commencement. 3.3 says, Todd is coming and he's going to implicate you.
Yeah.
And, by the way, with respect, before I allow that submission to disappear in the list of obscurity, he did just that.
Yeah.
Through much speculation and conjecture through sensationalism and, as I will demonstrate later if time permits me to do so, with evidence that is not factually correct. So we say with respect, Mr. Chair, I have regard to what Rule 8.3 says. All I want to advance before, Mr. Chair, is that this Commission will be in a better position to determine where the truth lies, particularly when you have regard to paragraph 22.1, when it says, well, he sensationalized in the context of him coming to implicate me.
Yes.
Because it all is aimed at one thing, Mr. Chair, and I don't want to reinvent the wheel. It's all aimed at one thing. Gama was described as one of the three architects of state capture. If we consider that allegation alone, it's serious.
Yes, but hang on one second. I think we have dealt with the issue of the email that he says Mr. Todd said he was copied on, and he admits he was copied, but he says he sought to sensationalize his evidence. What other allegation of fact is disputed between the two of them? In
relation to that point, or might I continue with the affidavit?
No, in relation to another point.
Or other points.
Yeah, other points. That's what I'm looking at.
Thank you. So, if we then in turn deal with what is contained at paragraph 42 of the founding affidavit, it deals with the participation by Mr. Todd, together with a partner of his at the law firm, Bowman's.
I'm sorry.
Paragraph 23, Mr. Chair, of the founding.
Paragraph 23.
Indeed.
Oh, okay. Yes.
So, what happens there, Mr. Chair, the Chair will recall this evidence by Mr. Todd, where he says, well, I went to a meeting with Mr. Molefe, but we hear nothing more about what transpired at that meeting. Mr. Chair, here's the importance and the nub of what I advance in support of this application as it pertains to this paragraph. Meeting notes were prepared. We were never favored with a copy of that. But in this context again, because remember, Mr. Chair, what this seeks to achieve through the testimony of Todd is simply this. This reinstatement of Gama took place with no rational basis for it, and in particular this aspect, the halting, as it were, of the litigation against GNS, or Abalosi as it became renamed.
Well, you see, it's going to be more helpful to me if you start by telling me this is the allegation Mr. Todd made according to the founding affidavit at paragraph 23 that Mr. Gama takes issue with.
What Mr. Gama takes issue with?
Yeah, so in other words, what is the allegation made by Mr. Todd against Mr. Gama in paragraph 23 that Mr. Gama takes issue with?
He takes issue with the fact that there's no disclosure as to what transpired at that meeting. Mr. Molefe is presently the subject matter of his evidence before the Commission. I don't know that that aspect has been dealt with. I don't think it's been raised with him. So my client is in the dark. But this is what we say. And Mr. Chair, I hasten to add this. The purpose with respect to cross-examination is not merely to elicit contradictions. The purpose is to elicit concessions, particularly in circumstances where Mr. Todd has created a perception. We want to disturb that inference that may flow from that perception having been created by means of cross-examining him and eliciting certain concessions. In this instance, since I'm pressed...
So under paragraph 23, what you are saying to me is that there is no positive allegation that Mr. Gama relies upon, which was made by Mr. Todd against him, but his issue is that Mr. Todd did not include in his affidavit or evidence what transpired in the meeting that he held with Mr. Brian Mlefe. His issue is the fact that he didn't say anything about the content of the discussion.
Mr. Chair, partly.
Yeah.
That's partly correct, with respect. However,
Yeah.
again, I emphasize the context within which this evidence was given. Because, you see, it's in the context of undue, untoward influence. No rational basis for the halting of that litigation against Abalosi. And here's the point, if you'll permit me to just finish this point, Mr. Chair. The point really is this. What we later on learn is that there was good reason. There's what we call the Harris-Nupin-Molabatsi report that says, but here are facts advanced during our investigation which show that there was work performed by Abalosi. It's in the context of that we say, but play your hand, Mr. Todd.
Yeah.
Tell us. You can't talk about things which we've not seen, which we're not a party to, in the context, again, of you implicating our client in the so-called undue attempt to stop the litigation.
Of course, if Mr. Todd has said nothing about the content of the discussion and your client has evidence about what transpired, then his evidence would be unchallenged by Mr. Todd.
Mr. Chair, he doesn't have that evidence, and this is what we seek to explore in cross, because if we cross Mr. Todd on this point, forgive me, Mr. Chair, if we cross him on the point and we establish that at that meeting, Mr. Molefe conveyed to him the reasons why this litigation was halted, well, then it flies in the face of his testimony before this commission, which was that there was no rational basis, at least not to his knowledge, for this litigation to have been halted. Mr. Chair, that's my respectful submission.
Yes, okay, all right.
Thank you.
And then is there another disputed fact between the two of them?
There are a number, Mr. Chair. I don't want to waste your time.
Well, if you tell me where they are to be found in the founding affidavit, then that would help.
Yes.
But I remember that when I was reading the founding affidavit, I thought possible two, but you say there is a number, I must have. So let's identify them in the affidavit.
Mr. Chair, it follows, there's this theme that runs throughout this founding affidavit with respect, and it deals with these issues. And if you just have regard to the very next paragraph that follows, the one which we've just dealt with, it's again this perception created of this undue influence. Because you will recall the testimony of Todd.
Yes, let's start in the founding affidavit. Tell me which paragraph you are now.
Paragraph 24. We say,
24, what's the allegation it says Mr. Todd made against him?
I quote, to the extent that Todd's evidence creates the perception that I had somehow interfered with or influenced the withdrawal of the action against Abalosi, I deny any such alleged interference and or influence in the process.
Well, he's not sure if Mr. Todd makes that allegation, but he says in case he does, he denies it. On the face of it, it seems to me that could be dealt with when Mr. Gama gives evidence and says, well, if that is what Mr. Todd intended to say, and I'm not sure that he intended to say that, that's not the case.
Mr. Chair, with the greatest of respect to the Commission, the purpose of cross-examination, again, is...
You must remember that the in terms of the rules, you know, when I look at an application for leave to cross examine, I must think about the work of the commission and the interests of the commission. It may be that for a particular individual, it might be very important to cross-examine a certain witness, but it may well be that it won't advance much the work of the commission in terms of its terms of reference. It's on some point that the individual affected might think is quite important for him. But in the end, I must look at the interests of the work of the commission. And that interest right now also takes into account the limited time we have. So if I grant leave, I must be satisfied that with the limited time we have, it's really appropriate, important.
Mr. Chair, I fully appreciate that. But I simply want to make this one response. It won't serve this Commission's interests to have two competing versions in circumstances where neither of them, or at least not that of Mr. Todd, has been tested under cross. But I fully appreciate the sentiment expressed, and I respect that. Mr. Chair, so we go further, paragraph 24, and again, the context within which there's this reference to it, and there are two separate memorandums here, but again, and just so that we don't waste time, it's said in the context of my client having had a hand in this so-called undue influence. I want to cross-examine Mr. Todd. I want to ask him, where is your evidence for this? Because you didn't disclose it then. He says things like, my client took certain steps. What were they? You can't give evidence in chief, as I term it, without making a full disclosure. With respect, we ought to be able to test that version.
Okay, what I will do now, I mean, obviously, this is quite important for your client. I propose to limit the time. Is it fine if I give you 10 minutes? And I'm not going to interrupt you much. 10 minutes to make all the submissions you want to make. Is that time fine?
I'm a long-distance runner with a long breath, but I'm going to do my level best, Mr. Chair.
Okay, all right. Let's try and do that. I just see that it's been over, I think, 40 minutes, if I'm not mistaken.
As you please.
Yeah.
Thank you.
Okay.
Mr. Chair.
But I've asked you questions, so that has taken some time as well.
Yes. Mr. Chair, I'm going to commence then by doing that, by having regard to paragraph 25. It is an aspect that deals with the condemnation. You will recall the testimony of Mr. Todd, how he told you that he couldn't see, as though he was an expert witness, he couldn't see how condemnation influenced the process. I say in paragraph 25, you simply needed to have reference to Nkonki and KPMG's report to understand the importance of. And here's the significance. That report served before the board. That report, and because I'm under time constraints, I'm not going to read the report. That report says, for instance, we have investigated, we have found that in the past, the condemnation process was employed. Mr. Todd says it was never employed with reference to procurement processes. Absolute nonsense. The report makes it clear that it was employed. We want to cross-examine Mr. Todd. We want to understand on what basis and what motivated him to make that submission, that it didn't matter. When the Nkonki report, which was its specific purpose to investigate this aspect, and this is crucial, Mr. Gama was not given the opportunity by Ms. Ramos, the Group Chief Executive Officer, if my memory serves me correctly, at the time to have applied for condemnation. He
could have initiated that. He was the CEO. He could have requested it.
My understanding of the process and the protocols works, you must be given leave to apply for condemnation. it is common cause that he wasn't given leave to apply. And what's particularly of significance, Mr. Chair, that aspect, it would appear, is something that persuaded not only the chairperson of the board in the form of Mr. Mkwanazi, but also the board as a whole, with the one or two dissidents, to then find that the interests of justice, the probabilities, and we have regard to the Norton Rose report that says, well, you know what, you didn't allow this condemnation process. It proves problematic. And it was on that basis that the referral to the arbitration, or rather the bargaining council, as it were, was abandoned and the settlement discussions commenced, which resulted in a settlement agreement being concluded between my client and Transnet as a whole. That's not what you're told. There's scant regard for that. If only he had read the report properly and had placed that before, Mr. Chair, it's a very different world and landscape. I want to cross-examine him. I want to ask him, why is it that you put this set of facts and you're selective in what you're doing? I think it would be best served for the Commission's work to understand why that happened, instead of simply mero moto accepting that the evidence of Mr. Todd is correct, because clearly it is not, with respect. I hasten to move on, Mr. Chair. Time constraints.
Yes.
Don't permit me to dwell too much on that aspect. We have paragraph 26 of my founding affidavit. It refers to the report by Denise Rate's attorneys. And it's very important that I simply tell you what this report says, Mr. Chair. That there is a probability, not possibility, as Mr. Todd contended for, a probability. And we know in law, the one has more prospects of happening than the other. A probability that the bargaining council or a court considering the appropriateness of the sanction of dismissal of Mr. Gama may reach the conclusion that dismissal was not appropriate, having regard to the challenge in sanction advanced by him in that instance. The court may either award compensation to Gama or find that a lesser sanction ought to have been imposed and therefore order his reinstatement. It's not as though there's no reason, no motivation, no rationale for his reinstatement. You instruct a firm, a well-respected firm of attorneys, one of the biggest in the country, to give you an opinion, and that opinion leads to this conclusion. Just like Mr. Todd is a partner of one of the biggest law firms in this country, so was Denise Rates prior to it being incorporated into Norton Rose. They sought the opinion, they received it. Whether we sit today, and as Mr. Todd did, he's not an expert witness, and this is the crux of my submission. He comes before you, with respect, Mr. Chair, and he wants to sit and interpret. He wasn't a party to the negotiations. He wasn't a party to the advice sought and obtained. You don't come and you give this sensationalized version of, well, my interpretation is not that. Let me take you to the next example. You have the evidence of Mr. Molefe in the form of a letter sent by him. You have Mr. Mkwanazi. You have Mr. Mapoma who says this. Well, this interpretation that the aspect concerning the legal fees is not something that was entertained, that's not correct. That's Mr. Todd's version. His interpretation of something to which he was never a party. Our version is that it did include the costs. Just by the way, something which...
But that's just a matter of interpretation of the settlement agreement, isn't it?
That's his interpretation.
No, but the settlement agreement settled the dispute on certain terms, and those terms are in the settlement agreement, isn't it?
I by no means, I'm not...
There might be different interpretations of what the agreement means.
Yes.
That maybe
this is my submission. I'm not a commercial lawyer, but I can say this. The little knowledge I have of commercial work is there's a thing when you interpret the conduct of parties, which is contract by conduct. The conduct we have is paid. I beg your pardon. I'm also seized there with matters. Transnet paid. Mr. Chair, but this is important for your purposes. That 1,016,000 rand payment, which Todd tells you It's bizarre. There's no cause. Let me tell you, Mr. Chair, it's not true. That payment, following the High Court order, where my client lost his application in his bid to stop the proceedings, that was a payment which my client made, by the way. And when the settlement agreement was concluded, that money was paid back to him. But I'm going to continue with the affidavit.
Yes. Well, before you sit down, there is still about 3 minutes. One of the things I want to raise with you is this, that it may well be that I should wait and not make a decision on the cross-examination application and let Mr. Gama take the witness stand, give his side of the story so that, and let him be questioned by the evidence leader as Mr. Todd has been questioned, and see whether at the end of that, how much is still there that really requires to be resolved by cross-examination. Because if at the end of his evidence, it becomes quite clear that really there is not much in terms of dispute between them, there might be no need. You might not pursue the application yourself. So that there is that is also in my mind to say, well, Mr. Todd has subjected himself to questioning by the evidence leaders. Maybe if Mr. Gama did the same, and then I have both sides, the picture as to where the disputes lie might be clearer. So I would like you to say something about that as well.
Mr. Chair, I think, and I say this with respect, that's a very wise proposal by Mr. Chair as to the future conduct of, in particular, this application is concerned. But Mr. Chair will appreciate, no doubt, that I'm a creature of instruction. And if you permit me, in circumstances where I can say to this commission, my client feels very strongly about this application, if I'm permitted a very short adjournment, a few minutes, to canvass this issue, it would be naughty of me not to do so and return to a concession in that regard. If you permit me that opportunity, it may be a wise approach to the matter. Might we take that short adjournment so that I can consider it, because I'm not anywhere near the conclusion, but I do understand that there are time constraints.
Yes, no, that's fine. Mr. Mybeck, is that fine with you? Okay, let's take a 5 minutes adjournment. Just a 5 minutes adjournment.
Thank you, Mr. Chair.
Yes, we are back.
Mr. Chair, we've taken instructions. We concur with the view expressed by Mr. Chair, and then we propose that there not be an ultimate determination of this application until such time as you've suggested.
Yes, yes. No, I think that's good. So we would defer the application to after he has given evidence, and then we can take it from there.
There is, and I don't want to appear to be opportunistic, there is potentially an application of sorts concerning the evidence of Mr. Gama, particularly as it pertains to the Fundutsi report. But it is something that I've discussed with Mr. Myberg, and the suggestion very early this morning, as discussed between us, was that we approach you in chambers for that purpose, and I'm simply requesting that we be granted that opportunity. We will be very brief.
Okay, you say that's an application for?
It depends in part. The relief is twofold. One, that Mr. Gama not be interrogated concerning the Fundutsi report, but that he continues with his testimony, and that at a later stage he will be given an opportunity to deal with the Fundutsi report, and he may for that purpose be recalled upon receipt of a further supplementary affidavit from him. I make this submission before you, Mr. Chair, in the context of this application will also be held over until that final determination, as it were.
Okay, no, that's fine. I think what we'll do is that we'll defer this application, and that's one. Two, I would think that we then continue with Mr. Mlefe's evidence, but at some stage, you and Mr. Myberg could approach me about that other issue relating to the Fundutsi report. At some stage, maybe later today, or whatever time. That's what I think. Or did you want to talk to me now before we continue?
There is a measure of urgency to what we want to discuss, in the sense that if there's no compromise, we're going to serve our application, and I don't want to do that because it's going to lead to a whole new set of consequences. So if we could, if Mr. Chair will indulge us for a few minutes, now, we would really respectfully appreciate that approach.
Okay, let's do that then. Let me adjourn, and then the two of you can see me, and then we'll take it from there. But otherwise, this application is then deferred to, and will be dealt with at a later stage after Mr. Gama has given his evidence.
As you please, Mr. Chair. Thank you.
Okay, all right. Okay, we'll adjourn for 7 minutes. We adjourn.
And you can put wherever you like, and we will call, we'll sound the trumpets.
we ready to continue with Mr. Molefe's evidence?
Yes, thank you, DCJ.
Yes, okay, let's continue. The affirmation you took yesterday, Mr. Molefe, will continue to apply today.
Yes, Chairperson.
Thank you.
Thank you, Chairperson. Good morning, Mr. Malefe.
Good morning.
I just want to go back a little before I go forward. Yesterday, we dealt with the session by McKinsey to regiments. Do you remember that? We dealt with it.
Yes.
So it was on the 16th of April that Mr. Sagar of McKinsey advised Mr. Singh that McKinsey had, with effect, from the 5th of February,
Yes.
ceded its rights and obligations to regiments. I just want to, I think you might have raised the point with me as to whether there was anything wrong with that session from McKinsey to regiments. I would just want to refer you to...
I'm sorry, Mr. Mybeck, just some housekeeping. I don't propose to take another tea break. We'll take tea break. So I propose that we proceed until 1 o'clock.
Thank you,
If that's fine with everybody. But if an urgent need does arise, people will let me know.
Thank you, Chairperson.
Okay.
So I just want to raise one thing with you, or point out one thing to you. Could you please go to Bundle 6, to the M&S report? So this is then volume 27.
We are at
Bundle 6,
Bundle 6, okay.
Exhibit 27.
Yes. Which page?
Page 383.
382.
I just want to point out one thing to you. If I could ask you to have a look at paragraph 2.4.20. In dealing with that session, M&S say that this session was invalid on the basis that at the time when McKinsey purported to cede the contract, McKinsey's rights in respect of the transaction advisory services had lapsed. And that's because the LOI, the letter of intent, was provided for a 90-day period, and it lapsed on the 30th of November. Do you want to just comment on that single finding or made by M&S?
I also note that the session was not approved by Transnet, and that the session was only approved the following year,
Yes.
in April, sorry, in May. The LOI was,
Mr. Malefa, I noticed that you're reading from something on your phone.
yes,
I don't necessarily have an objection to that.
Yeah.
Protocol would be that you would
Yeah.
then have to share with us
Yeah.
anything that you're reading from that's in writing.
it's my notes that I made last night.
As I say, I have no objection to that, but the protocol is they should be shared with us.
I have not made copies of these notes, but it's just a handwritten notes on the phone.
Have you got a hard
okay,
copy of the same notes?
Can I use my notebook then
To do what?
to read from?
Or you have made notes on the notebook?
On the notebook or on the phone, it's the same notes.
Yes, you say the notes are both on the phone and in the notebook?
Yes.
Same notes?
Yes.
Yes. Okay, then Mr. Mybeck is simply saying, then if they could have copies of the notes that you are going to use.
The copies of the notes that I made on my notebook.
Yeah, if
as
you
I
are going
was
to
reading.
rely on them in giving evidence.
But I'm just going to.
If you are not going to rely on them, obviously, you don't have to share them.
No, but Chair, these notes are to remind me exactly what is written in this document and where it is.
Well, Mr. Maybeck, do you want to?
I wouldn't like for the questioning to be delayed. Perhaps it's something that we can try and deal with at lunchtime.
At lunchtime.
And if you could perhaps on that basis permit Mr.
But Chair, if I see a section here that I want to refer to, and then I write on my notebook that paragraph 2.4.21, must I then share that?
Well, it's innocuous like that, therefore you wouldn't have any problem even if you were to share it. But Mr. Maybeck has requested me to allow you to look at them, and then around lunchtime, there can be a discussion. There can be a discussion about the use of the notes.
Okay, I won't use the notes.
All right.
So
It's really just a simple point. I mean, I'm just pointing out to you the finding. You can deal with it if you want or not. They say that the session was invalid because the LOI had expired. It's really as simple as that.
yes, but the LOI had been renewed several times.
All right.
And what I was just about to check now, because I did make a note about it, was that in the 3 times, it was renewed 3 times, but I think it was also renewed, the MSA was then entered into at some point.
Yes.
So I just wanted to check exactly when and how this
So,
was done.
Mr. Molefe, just so that I capture your evidence, you say you dispute that point because you say the LOI had been extended.
No, I wanted to verify it for myself, Chair, but now, if I can't use my notes, all right, I don't dispute it.
All right, now you don't. Fine. So let's then go, please. We added the page. Remember when I read to you about Regiment's Capital's replacement of Nedbank? I read you a letter yesterday. But that's been inserted now into Bundle 5, Exhibit 22, your exhibit. Could you please go there?
Regiment's letter.
Page 405.96.
In bundle 5.
Yes. So that would be after, right at the end of the file, after the CIPRO reports.
It will be 405.96.
96, Chair.
Yes.
So this is the letter that I read yesterday. You see it's from Mr. Singh, dated the 19th of November.
Yes.
And ultimately, we've been through this before. It's really just a matter of placing the letter properly on the record.
Yes.
The letter ends by Mr. Singh saying, this letter serves to confirm Transnet's agreement to McKinsey's request for Regiment Capital to provide the required services in place of Nedbank. You see that?
Yes. Nedbank was conflicted, and because they wanted to do the funding as well. And McKinsey confirmed that Nedbank was conflicted.
Yes.
And my understanding is that Regiment had a choice as to who should replace Nedbank in their consortium.
Yes.
And they chose Regiment of their own volition.
McKinsey chose Regiment.
Yes.
Are you aware of the evidence in relation to Mr. Segar at McKinsey?
Which part of the evidence?
That there seems, as we went through yesterday, there's a possibility that we can go back to the report, was dealing with Mr. Esser.
With?
Mr. Esser.
No, I'm not aware of that.
But you confirm that Regiment's Capital then replaces Nedbank, as per this letter.
I confirm that McKinsey
Yeah.
then replaced Nedbank with Regime.
Now,
And that is in the MNS report.
yes, we're going to come back to that. Now, I also yesterday gave you the opportunity to reflect on two memoranda overnight. We hadn't dealt with the one, but we had dealt with the first one.
Yes.
Could I ask you please to go back to page 405.1?
Of which bundle?
Bundle 5.
Oh,
405.1.
bundle 5.
Yes, bundle 5. Page 405.1.
Yes.
So, Mr. Malefe, just to orientate you, this was the memorandum that you approved, where you approved of the replacement of Letsema. Is there anything that you want to, now having had the opportunity of studying it, is there anything that you want to say more than what you dealt with yesterday?
You say this memorandum approves the appointment of Letsema.
The memorandum you see at paragraph 1.1 for the chief executive to note that McKinsey will be advised to partner with another firm with equal or better credentials than Letsema for the procurement elements due to potential conflict.
Yes.
Is there
Letsema-
anything you want to
Letsema
add?
had a conflict
Yes, I know that.
because Barloworld, which was advising them, was also building engines for Caterpillar, which engines were used by EMD, and EMD was a bidder. So Letsema had a conflict. What then happened is that the McKinsey was informed of the conflict and then asked to appoint somebody else instead of Letsema.
So who picked up the conflict, not McKinsey?
I think it was Transnet,
Yes,
but
who?
the conflict was real. I'm not sure who picked it up.
Was it you?
No, I say I'm not sure who picked it up.
Is what I'm asking you, was it you?
No, no, it wasn't me.
So you don't have first-hand knowledge of this?
Of the conflict.
Well, you didn't pick it up. You say it was brought to your attention, presumably.
It was brought to Transnet's attention. This conflict must have been picked up in the process of receiving the bids, or I don't know, but they knew that EMD's engines were going to be, EMD's engines were Barloworld engines from Caterpillar. And so EMD was bidding, or intended to bid, for the 1064. And so there was a potential conflict, and this was raised. And then after it was raised, unfortunately, I don't have the piece of paper where
You
it was
see,
raised.
Mr. Malefe, you said something quite important. You said this was picked up during the bids, and then I think you sought to correct yourself. Because, of course, it wasn't picked up. Because what we know, and we went through this yesterday, we know that on the 27th of July, the contract was awarded to the McKinsey consortium, including Letsema. Now what we see on the 22nd of August, about a month later, is a decision in terms of which Letsema should be removed. So I'm sorry if I'm just going to press you, I'm going to ask you only one more question. You don't know who brought this to your attention, and you don't know why it wasn't picked up during the bids. Is that correct?
No, not during these bids.
Yeah.
Not during this, the appointment of the transaction advisor, but after the appointment of the transaction advisor.
Yes, that I know.
I can't recall how, but last night I did jog my memory.
Yeah.
And remembered that Ballowell engines, Caterpillar engines, are used by EMD, which is an American company. And EMD had expressed an interest to bid for the 1064. And as I recall, Letsema was in partnership with Ballowell. And so it was pointed out that this is a conflict. Letsema can't advise on the award of the 1064 when the engines for one of the bidders was coming from Ballowell.
So just so that we
So
can move on.
unfortunately, because I'm not at Transnet, I don't have access to the documents. But as I was sitting and remembering the situation, this is what came to my mind, and it actually just came back very clearly.
So I want to just confirm two facts before I move on. You confirm that it was something picked up by Transnet,
Yes.
right? And secondly, you don't know why it wasn't picked up during the bid adjudication
No, I
process.
don't know why it wasn't picked up during the bid.
And thirdly, you don't know who brought this to your attention.
I can't remember who brought this to my attention. But, Mr. Myberg, if you're interested, you can certainly ask Transnet to provide information on this. I'm sure that there is information at Transnet.
Or we can ask Mr. Singh, I suppose.
You can ask Mr. Singh.
Can we
but
then get
it
to
would be
the-
easier to get the documents from Transnet.
Can we then go to the next document? And that you find at 105.7. I just started dealing with this yesterday when you indicated that you needed more time to reflect on it. And we then adjourned early to enable you to look at it. Now, I want to go through this.
105.7 in the same bundle.
Yes. What you did confirm yesterday.
I'm sorry. You said 105, is that right?
One,
Or
sorry,
405?
405, I beg your pardon.
Okay. Point?
0.7. So if you could just, if I could take you, please, just to get you to confirm again what you dealt with yesterday. If you go to point 15, 405.15,
Yes.
so you noted that Mr. Singh had sent this to you on the 16th of April, 2014.
Yes.
And we confirmed that that was the same date that Mr. Sagar had advised Mr. Singh of the cession to regiments. Correct?
It was the day before.
Did you say 405.16?
Yes.
405.15.
Oh, okay.
It's dated by Mr. Singh on the 16th of October 2014.
Okay.
Yes.
And yesterday you confirmed, and we went through the documents, Mr. Molefe, that that's the same date that Mr. Sagar of McKinsey advised Mr. Singh that McKinsey had ceded its rights and obligations to regiments.
Yes. With effect from the 5th of February.
Yes, but it's exactly the same date.
Yes.
So let us then go through this document, if we may, in more detail, and let me not just go to the conclusion. Now, just to locate and perhaps remind the chairperson, the net effect of this is ultimately there was approval for payment to regiments, I think, of an additional 78 million rand in fees, correct?
The correct.
So let's go through how that came about, and let's have a look at
You
the.
just asked me a question.
Yes, we're going to deal with a memo, and we'll get there.
No, I was just going to say the correct terminology would
Fair
be.
enough.
The correct terminology would be that this document is a model for the remuneration of the transaction advisor.
Yes. Yes, it's a changed model.
Yes, this is a new model.
It was proposed on the same day that McKinsey fell out with all its rights and obligations ceded to regiments on the same day, correct?
Yes.
All right. So let's then go to page 405.7. And let's go through this thoroughly, because I think you're right yesterday when you indicated that it's certainly deserving of this. Because, of course, we know that you approved of this. Let's have a look at paragraph 1. The purpose of this memorandum is to request the Group Chief Executive to sub 1, note the deliverables executed by the transaction advisor on the Locomotive transaction compared to the original scope per letter of intent. Now, who's the transaction advisor there that's being referred to?
I'm sorry, Mr.
405.7.
You have lost me, or I have lost you.
Bundle
405.7
DCJ.
or 70?
7.
7. Oh,
It's a memorandum to Mr. Malefe from Mr. Singh.
yes, I've
Just
got
hang on,
it.
just hang on a moment. Do you have it, DCJ?
Yeah, I've got it,
All right,
thank you.
yes, Mr. Malefe.
I
Who is the
didn't-
transaction advisor referred to here?
I did make notes, and I would request that, and actually, they are typed out properly. And I would request that when we get an opportunity to print them, that we share them, but that I be allowed to refer to them.
Yes. Okay. Mr. Mybek?
I just want to make the point that this is something that you were asked to deal with in your affidavit.
I did.
And
No, not in my affidavit, yesterday when I got this document.
Chair. Chairperson?
Yes.
As I understand it, Mr. Mulivu does not have any problem with sharing the notes that he prepared
Yes.
last night
Yes.
for the purpose of this hearing.
Yeah.
I don't know why should it be difficult for this hearing to accord him the opportunity
Yeah.
to refer to the notes, because he's prepared to share these notes with the inquiry.
Well, if he is prepared to share, is there any problem, Mr. Mybek?
No, of course not. I mean, that was the whole point that I made at the
Yeah.
outset.
Yes.
I understood that Mr. Malefe had decided he's not going to refer to his notes.
Yeah,
If he
initially,
now wants
yes.
to refer to them, and they
Yes.
have been typed out, then perhaps it's best that we just get a copy,
Yes.
and especially if it deals with this.
Yeah.
I am going to take Mr. Malefe, though, and I'm going to point out to him the 10-6s that were issued to him, where, in fact, to the best of my recollection, was asked to deal with this. But, Chair, we're in your
Yes.
hands if you
No,
wish.
no, no, that's fine. You don't have copies, you just have notes, but you tender them.
I have the notes
for-
in soft copy. Chair,
Yeah,
my understanding is that I'm here to assist the commission
yeah, yeah,
and
Yeah.
to give evidence
yeah,
to the best of my ability.
yeah.
And that is what I'm trying to do. And
Yeah.
I'm saying that to do that,
Yeah.
I need to refer to what I
No,
wrote
no.
last night,
I think it's resolved
after the
now.
discussion that we had last
Yes.
night.
I think it's
And
resolved.
I do not understand why it then becomes necessary to refer me back to the notices that were given me some time ago. Because
Well, maybe it will be clear why, at the time that Mr. Mybek will refer you to those notices, why. But I think the issue of you using notes is now resolved. As I understand it, there are no copies readily made available, but you are ready if somebody from the legal team, technical team, wishes to make copies, those can be made.
Certainly. So,
Okay,
Mr.
all right.
Malefe, as I say, let us sort that out over lunchtime. Maybe the notes can be mailed to someone at the commission and we'll then print them out. Don't have any difficulty with you referring to your notes if you wish to on this. All right? Now, but before you tell us what's in your notes, I'm going to take you through this memorandum.
but are you not,
Yeah, just,
are you going
Mr.
to allow me
Malefe,
to answer the question that
I want you to please answer my question. At paragraph 1.1, when it
But
refers
there
to,
was a question before that one.
the question is, who is the transaction advisor referred to in paragraph 1.1?
Yes,
Who is it?
that is why I wanted to refer to my
Right.
notes. If you will allow me, sir.
Are you able to tell us, before you go into a long explanation, who the transaction advisor is or not?
The MSA was not concluded on time.
Mr. Malefe, I'm happy to allow you to explain yourself, but are you able to tell
Chair,
us who
I'm
the
really trying to help the commission with information
Yeah,
that I have.
yes.
And if Mr. Mybeck is going to interject and pin me into answers that are not helpful, I don't think it's good for the commission. I don't think that the objective of the commission of arriving at the truth will be achieved.
No,
I think that Mr. Mybeck must exercise some patience.
Yes,
and-
no, no.
and listen.
I don't think there really is a problem. What he has put to you is a question that says, do you know who the transaction advisors are that are referred to in, is it paragraph 1.1, Mr. Mybeck?
Yes, and if I
Or
might just,
paragraph 1?
1.1.
Yeah. Now, it helps to start by saying, yes, I know. If you want to elaborate, we can take it from there, but yes, I know, or no, I don't. You know,
But
it helps.
give me 15 seconds to say what I want to say.
Yeah, yeah. What
Which is that on the 21st of February, the MSA was concluded with McKinsey. On the 21st of February. Now, the reason this is confusing is because later on the 16th of April, McKinsey then says that, no, we are ceding everything to
Regiments.
regiments. And yet, from the 5th of February, and yet McKinsey had signed the MSA on the 21st, on a date after it had exceeded the transaction exposed to a date that is preceding. So, as I was reading this, I myself got confused and wondered why the legal people never picked this up. So the answer to Mr. Mybeck's question, I don't know, is not a straightforward answer. Because McKinsey signed the MSA, which made them the transaction advisor. And then later on, they ceded it to, they ceded the agreement to regiments on a date that is before they signed. So actually, it's not a straightforward answer.
So you
even
wanted to
even
say-
as I'm sitting here, I'm confused
You
about.
wanted to say, it's confusing, I don't know what the answer is.
I don't know what the answer is
Yeah,
because it
okay,
is
all right.
confusing.
Yeah.
And even if I was going through this, I was wondering myself, but perhaps the legal people who were drafting these agreements and who were involved from a legal point of view on these matters should explain what really happened here. Because I was not even aware of this until I went through it last night and did proper timelines about who did what when. But what then happened is I was the MSA was signed by McKinsey on the 21st.
Yeah, before the actual session.
Before the actual
But the
session, but
session
the
referred
session
to-
was before the date.
Yeah.
Yeah.
The effective date.
The effective date was before the date that they actually signed. So I don't know actually that even on this day, if we had a transaction advisor, because then on the 21st when they signed, in terms of their session, they were no longer the transaction advisor. So I don't know who the transaction. It's a question that would require the legal people that were involved here
Yes, so
to
the
explain.
short answer is you don't know.
I don't know.
When you read this, because of course you approved this, it's a hugely important
Yes.
part
And the-
of, sorry, do you mind if I could just finish?
Yes.
When you read this document before approving it, who did you think the transaction advisor was there?
When I read this document,
I'm talking about at the time, Mr. Malefe.
at the time, yes, Mr. Mybeck, I was talking about at the time. I don't think it was necessary to remind me about that it was at the time. That is exactly what I was trying to say. Please don't put words into my mouth, Mr. Mybeck.
Could you please just answer my question?
Could you please allow me to answer your
Fair enough.
questions? When I read this at the time, this was a model of how the transaction advisory services, I mean, the transaction, as I call it, the remuneration model for the advisors would work. And when I read this model, it was, at the time, it was with the understanding that we have appointed transaction advisors. I was not aware of all these contract legalities of contracts that had transpired in the background. I thought that what was presented to me was that we have advisors, and this is how we're going to share, how we're going, the remuneration of the transaction advisors is going to work. So this was an approval of a remuneration model for the transaction advisors.
So then, at paragraph 1.2, it says ratify the amendment to the allocation of scope of work from McKinsey to Regiment's Capital, correct?
Yes.
And I think we understand that context. Sub
Yes,
3,
and my understanding of that was that McKinsey, as the main contractor, is allocating some work to be done by regiments. I thought that is
That's what you
normal
thought.
in the context of subcontractors.
Sub
So
3,
I was not aware of what I had explained. I have explained earlier that in fact there had been, in fact, the session that happened on the day that the memo was sent to me,
yeah, same day.
as well as that it was up from the 5th and that they had signed the MSA on a later date.
So sub 3, ratify the amendment in the makeup of the transaction advisor consortium from Nedbank Capital to Regiment's Capital. I think we've dealt with that.
Yes.
Sub 4, approve a change in the remuneration model
Yes.
of the transaction advisor compared to the original remuneration model.
Yes.
Sub 5, delegate power to the GCFO to give effect to the above
Yes.
approvals.
Yes.
Then, if we go to the background, because
just to add, Mr.
Certainly.
Mybeck, I had no beef with those intentions of the submission.
then we get, although as I understand you to be saying, at the time you didn't know of the agreements and the background.
Yes.
All right. Then if we go to the background, it says at paragraph 2,
Yes.
the GCE, and a lot of this we've dealt with already, the GCE
Yes.
approved the appointment of the McKinsey-led consortium to provide complete advisory services on the 1064 Locomotive tender. The letter of intent was signed by the Group CFO on 4 December 2012. We know that that was signed by McKinsey on the 6th for 35.2
Yes.
million. So that's how things started.
Yes.
That I think we've gone through yesterday.
Yes. And
3,
then that letter was amended 3 times.
3, a separate letter of intent was signed for Weber Wenzel. We needn't deal with that. 4, in May 2013, a potential conflict of interest was raised with McKinsey concerning Nedbank Capital, to which a response from McKinsey confirmed the conflict and an alternative as Regiment's Capital was proposed. We've dealt with that, correct? 5, on 19 November 2013, the Group CFO confirmed Transnet's agreement to replace Nedbank Capital with Regiment's Capital. That's the letter that I showed you earlier this morning.
Yes.
6, the entire scope of the engagement was allocated to Regiments, with McKinsey only responsible for the business case and limited technical optimization aspect. So that's the change, correct?
Yes. Yes. But this does not say that McKinsey is no longer in the picture.
Yes, no, absolutely.
It's just about the distribution of work in the consortium.
But the entire scope of the engagement was allocated to Regiments, with McKinsey only responsible for the business case and limited technical optimization aspects. That's,
As I say, this was
those
a
are the
split.
words.
This was a split of the work in the consortium. Yes.
So then what I want to do is to take you, please, to paragraph 10. And that you find at page 405.12.
Yes.
Talks here under the heading Value Created by Transaction Advisor, and then it deals with Regiments.
Yes.
Regiments assisted Transnet in computing the effects of hedging and escalation
Yes.
based on the original delivery schedule
Yes.
compared to an accelerated stroke revised delivery schedule,
Yes,
as well as optimizing the foreign exchange hedging and guarantee bond pricing.
yes,
11, this enabled Transnet to accelerate the delivery schedule, resulting in savings in future inflation-related escalation costs and saving in foreign exchange hedging costs, correct?
yes,
You could then drop down to paragraph 13, deals with the allocation of locomotives, dealt with in the previous paragraph. This allocation resulted in an increase in the cost per locomotive due to bidders having to allocate more of the overhead cost to a smaller batch. And then 14, the net saving as a result of this decision as calculated by regiments is reflected below. Then if you go over the page to paragraph 16, it records, as a result of the work done by regiments, the delivery schedule was accelerated, thereby ensuring that the locomotives arrived earlier, resulting in savings in future inflation-related escalation costs and saving in foreign exchange hedging costs of approximately 20 billion.
yes,
And then you say at 17, or it's recorded in addition, Transnet, through regiments' efforts, achieved a total saving of approximately 2.8 billion for the performance-based foreign exchange and guarantee bond, correct?
yes,
And then if you drop down to paragraph 20, regiments implemented this under the heading change in remuneration model for the transaction advisor. Again, it refers to regiments. Regiments implemented extensive intellectual property and complex techniques and methodologies to achieve the above benefits for Transnet, or to Transnet, hereby mitigating the risks identified above. Over the page, paragraph 21, the regiment's operating model for such engagements is usually based a risk-sharing model or success fee, 25% of value created or saved. Paragraph 22, in this case, regiments was transferred a mandate and remuneration model already accepted by McKinsey. Regiment's initial indications were that they would have preferred to be engaged on a model consistent with paragraph 21. 24, this initial request was rejected. However, based on the significant value created / saved, as well as risks mitigated as noted above, a request to amend the remuneration model was submitted. Consequently, an additional fee of 78.4 million, excluding VAT, is recommended to regiments, representing 0.042% of the saving. Is that right?
yes,
And then, under the heading PPM General Amendment Principles, it says amendments in excess of 40% of the original contract value or contract period will be dealt with as follows. Sub 1, in such cases, prior review and recommendation must be obtained from the appropriate AC first, as well as the original signatory. Thereafter, the matter be submitted for approval to the person with delegations 1 level higher than the original contract signatory. If you have a look at sub 2, however, this rule does not apply to amendments falling within the GCE, BADC, or board's delegation of authority. And then at sub 3, the rules relating to contract amendments stated above apply to contracts awarded via open tender as well as those awarded via confinement. And then at 28, in terms of para 27.2, the content of this request falls within the delegation of the GCE. You see that?
yes, I saw it last night when I was reading.
So that's no doubt why it was brought to you by Mr. Singh.
Yes,
And then we get the financial implications of this change. What we know at a point is that the contract value was in the order of 50 million. We've seen that yesterday. And now if you take the 51 and you, this then deals with the change in the model. If you look at regiments, Initially, they were going to be due 21 million. If one then adds this additional 78 million, one gets to 99.5, is that right?
Yes.
And it was really on that basis that the contract value increased from 51 odd million to 119 million, correct?
Yes.
Through this additional payment of 78 million.
Yes.
Okay. Then the budget implications, although it says at paragraph 30 the additional amount was not explicitly budgeted for, sufficient budget exists. And at 31, the additional fee of 78.4 million has not been included in the capital budget, however significant savings were achieved. And then the recommendation, which I took you to yesterday. It was recommended that you should, one, note the deliverables executed by the transaction advisor. That must have referred to regiments when we read it in context. On the Locomotive transaction compared to the original scope of the LOI, and as has been mentioned, that had been transferred to regiments. And then 3, ratify the amendment in the makeup of the Transaction Advisor Consortium from Nedbank Capital with Regiments Capital. 4, approve a change in the remuneration model of the Transaction Advisor compared to the original remuneration model, and delegate power then to the GCFO to give effect to the above approvals. So I think you summarized it well earlier. I mean, really what this memorandum captures is a change in the remuneration model applicable to regiments, correct?
However, I'm not sure if you understand, Mr. Maibek, that what this memo actually says is that for reasons stated in the memo, regiments managed to save us 2.8 billion rand.
Yeah.
So they saved us 2.8 billion rand as Transnet. And for the bringing into the kitty 2.8 billion, it was being recommended that they should be paid 78 million for the 2.8 billion that they had brought in. And the memo says that, well, it is not possible to pay them the 78 million because the original remuneration model does not allow it. This is despite the fact that regiment had protested in the beginning that they prefer to be remunerated on a different basis. And now regiment was coming back and saying, guys, I've already saved you 2.8 billion, so please can you reconsider the remuneration model that would effectively allow me to be paid another 78 million.
Yes,
Right? And what I simply did, I looked at the situation, I thought 2.8 billion is not bad for 78 million, and I approved it. That is, in English, that is what happened.
I think that you and I then see eye to eye on this. I mean, effectively, the change in remuneration model, you're right, the original model wouldn't have allowed this, but you reflected on the saving and you agreed to change the model and therefore agreed to pay them the 78 million.
78 million for 2.8 billion.
But, and we're going to come to the technical aspects in a moment. Of course, you didn't have to do this.
Chairperson, I didn't have to, but one of the things that was uppermost in my mind was that if these people have done what they say they have done, and they have saved us 2.8 billion, you really have to incentivize them to do more. Because by refusing, they will just stick to doing what they get paid to do. And that is not necessarily in the interest of the company. So it is a well-known principle in business that remuneration should be linked to the benefits to the company.
But that wasn't the original model. And have a look at paragraph 22.
No, the original model did not anticipate the situation
If I could just ask you to go to paragraph 22, just so that we understand, and I'll then engage with you. Paragraph 22, in this case, regiments was transferred a mandate and remuneration model already accepted by McKinsey. So I think it's common cause then, that model didn't provide for this, but because of the saving, you agreed to change it.
Yes,
in plain
because-
English, as you say.
Because of
Yeah.
2.8 billion rand that was on the table.
Yes.
Or
Except,
whether or not, 2.8 billion that is purported to be on the table, I was prepared to reconsider and say, well, if these people are performing so well, we should consider paying them 78 million out of the 2.8 billion.
and you accept that you didn't have to do that. It was quite generous
No,
of
we
you.
didn't have to,
Yes, it was generous
but
of you.
we could.
Yes, but I'm saying it was generous of you. I mean, you could have said,
No.
sorry, I'm just holding you to the, I mean, there was no,
No.
Mr. Malefe, there was nothing in law that was compelling you to do this.
Mr. Myberg, I'm
Yes.
telling you that the reason I did it, I didn't do it because I like regiment. I
Yes.
didn't do it because I have a particular dislike for anyone or whatever. I did it because there was 2.8 billion rand on the table. I don't know if you understand what 2.8 billion means for a company like Transnet, which made in 2016 a net profit after tax of 4 billion rand. It was not insignificant, and I think for 78 million rand, I felt that this could be done. This is a decision that would typically be taken by a CEO in my position. This was nothing out of line, Mr. Myberg.
All right. Well, you know what happened to half of this money?
I don't know.
No, you do.
Eh?
You do know what happened to half of the money, Mr. Malefe. That's the issue.
Did you say I do?
Well, from what you heard yesterday, do you have a sense of what happened to half of this money?
No, I don't know what happened to half of the money.
It was paid to Mr. Essa.
I
And then
didn't
it
know that
became-
at the time.
Well, that's
Even
why.
now, I don't know it, other than the fact that you said it.
You see, that's why this is placed under scrutiny, because you, I think, have accepted that this was generous. You didn't have to, in law, do this. You decided for business reasons to do it, on your view.
I think your question, Mr. Myberg, would be fair if it was. Had you known that half of this money would go to Mr. S, would you have taken the decision?
And what's the answer to that?
And the answer might be different. I don't know what I would have thought at the time. I don't want to speculate on it. But that is not what was on the table at the time. We're confronting objective facts.
All right.
And the objective facts are that there was 2.8 billion on the table. The people were asking to be remunerated for it. And I thought that for purposes of ensuring that in future we can even have more savings if we encourage them to do these structures that they did, we should pay them 78 million. What you came up with yesterday and what has come up in this commission are things that were not in my knowledge at the time.
Well, I think that, as you know, is
Because
part-
now you want to say that I was paying 78 million rand or half of it to Mr. Essa, and that is not true. I deny that in the strongest possible terms.
I understand that, but what you can understand why this contract is being placed under scrutiny. And of course, whether or not you knew what Mr. Essa was up to really needs to be decided. Once one's
and
gone through all the facts, one
just-
can't deal with it. You don't
Just to
mind.
repeat, Mr. Myberg, I actually didn't know Mr. Essa.
Yes. But we've been through that, Mr. Malefe. You didn't know him, but you had a seat at the table at the Guptas.
Yeah, but you're saying
And
the money
they
was
were-
paid to Mr. Essa. I'm
Yes,
telling you,
and
I
they-
did not even know who Mr. Essa is.
And they were the beneficiaries of this money laundering. He was their money laundering lieutenant. You knew them. That's the problem.
No, I knew when. Where do you get the evidence that I knew?
You knew the
I mean,
Guptas.
is it evidence that has been presented to the commission, or is it your own evidence that I knew?
No, that's
I mean,
not
where do
what-
you get it?
Sorry.
Why do you make such a wild,
I never said.
irresponsible accusation?
I said you knew
No,
the Guptas.
Mr. You can't say that I knew that they were going to use it for money laundering unless you are a,
Let me just retrace my steps, if you don't mind.
witch doctor.
Mr. Malefe, I was trying to explain in fairness to you why one needs to, from the Commission's perspective, place this memorandum under scrutiny. Just bear with me.
I don't mind
Just
what you are
bear-
going to, what you are trying to explain.
Right.
I take exception to the fact that you say that I knew.
No, that's not what I said.
What did you say?
So what I said
maybe
is
we
this.
should ask for the record to be replayed again.
Okay, let him say what he said, and let's take
I
it from
think
there.
the point that we
Chair-
made
Chairperson.
is I,
Sorry?
But Chairperson, the record will reflect that he said, you
Chairperson.
knew.
Yes, but let's hear what he says he said, because I don't know whether he completed his sentence before Mr.
No, he said
Molefe.
you knew what was happening and
Yeah.
paused and waited
No,
for
no,
my answer.
that's fine. One, if we need to check the record, it can be checked. But let's hear what Mr. Mybeck says he said.
well, I'd really like to cut through this. I mean, as far as you're concerned, you didn't know.
Yes.
Okay, all right. And what I was trying to get at is when I referred to Mr. Essa, you said you didn't know. I then pointed out to you that you actually knew the Guptas. That's where I'm going to. But if you say you didn't know this, well, that answer must be accepted now, and let us move on from this document. But I'm going to come back to the issue ultimately, and I've told you right up front that ultimately, whether you knew or not, and I'm sure you must accept, must be determined once one's gone through all of the evidence, and then you look back on it. Not one single thing would be determinative of that question.
Yeah, but I hope, Chairperson, that we are not in this commission to entertain Mr. Mybeck's preconceived conspiracy theories. I hope that we are here to listen to objective evidence that is not tainted by what Mr. Mybeck may have read in the newspapers, may have read in other affidavits, and so on. I'm not here to answer what is in Mr. Mybeck's head or to confirm his conspiracy theory. I'm here to give evidence. And my objective evidence is I approve this because there was 2.8 billion rand on the table, and that I did not know that Mr. Essa was involved. There is no way in this document that says that this money will go to Mr. Essa.
Yes, no, Mr. Molefe, that's fine. But remember what I said, I think yesterday, that each witness comes and gives answers to questions, but the evidence leader is not obliged to, at this stage, necessarily accept that as true. He is entitled to probe further, to test it, if he thinks it should be tested, as long as you are given a chance to deal with what he puts to you to try and test it. So he mentioned yesterday, if I recall correctly, that one of the issues as he sees them in regard to your evidence or your role will be whether, despite the fact that you had a certain relationship with Mr. Ajay Gupta or the Gupta family, the position is that you might not have known of certain things that the Guptas and their associates may have done in relation to Transnet, or whether you knew and therefore you may have been complicit, or it was a question of negligence, and then I think he said, or whether the question is whether they were too smart for you to pick up what they may have been doing. So when he was putting this to you, he wanted to make sure that as he puts questions as we go further, you know that these are the things he's trying to deal with, so that you can answer knowing the context, you know. So that in the end, if I ask him the question when he makes his submissions or presents argument at the end, if I ask the question, on this evidence, can it be said that Mr. Molefe knew what the Guptas and their associates were doing? He can say, I put these questions to him, or he gave these answers and I didn't just accept that. I probed further and these were his answers. Based on his answers, my submission is that he knew, or my submission is that he didn't know. So that's what he's trying to do.
Chair, my evidence is that I did not know, and I think
Yes.
in the interest of progress, maybe we should
Yes.
move on.
Okay, no, that's fine.
Chairperson, can I just once more just put it on record so that if it's possible we can be able to move on. Mr.
Yes.
Molefe has already said it yesterday and today. He has never met Mr. Essa. He does not know Mr. Essa.
Yeah,
So whatever Mr. may opportunity to testify freely in this commission, he should not be interrogated. And we've observed this from yesterday. Firstly, he was patronized on a few occasions, and he had to bring this to the attention of the commission. Secondly, it is as if he's in an interrogation room. I thought the purpose of this proceedings is to get information, and the witness should be able to do so freely. He shouldn't be harassed when he has to give answers in this commission. That's our request.
yes, well, let me say this. You will have noticed that in terms of the rules of the commission, there is a rule that says the evidence leader is entitled to ask questions to get to the truth of the allegations or the evidence. So you say should not be interrogated. So, but what I'm sure you agree is that when he gives evidence, as should happen with all witnesses, if the evidence leader wishes to probe further to test the veracity of that evidence, the evidence leader should be entitled to do that, as long as Mr. Molefe, as witness, is given a chance to respond to that. What would not be right is not to give him a chance to respond to it.
Chairperson, I agree, but I do not think.
Okay, I'm sorry. Let me deal with one. When I deal with your counsel, let me deal with your counsel. Yes.
No, that is clear, Chairperson, as long as ultimately Mr. Molefe is not going to feel intimidated.
Yes, no.
But
that-
how
no,
questions are also posed to him is very important, because if he feels attacked, certainly he's going to respond in a particular way, and I don't think we need to get to that point.
No. I think we all appreciate that we want to make sure there is fairness, but we want to make sure that there is proper understanding of what the evidence is and where it needs to be tested. It's tested, but there must be fairness throughout. Okay, all right. Your counsel spoke, Mr. Molefe. You look like you want to say something.
No, I didn't want to say something, Chair. No, I didn't want to say anything, Chair. I accept what my counsel said. We can lay the matter to rest as long as we remember that my understanding is that this is not an accusatorial hearing.
Yeah.
It is here to extract information to get to the truth. Now, the moment we start pointing fingers and said, you knew, despite the fact that I say I didn't, I think it is problematic.
But you understand what I said earlier on?
Yes, no, I
about
understand,
probing
Chair.
and so on.
Yes.
Yeah. Okay. Mr. Maibek?
Thank you. Mr. Molefe, could I ask you please to go to the M&S report, Bundle 6, Exhibit BB 27. And could you please turn up
Which page number?
385.
Yes.
It says, and I direct your attention towards the foot of the page, paragraph 2.5.9.
Yes.
Surprisingly, on 16 April 2014, Mr. Singh wrote a memorandum to Mr. Molefe to approve a change in the remuneration model of regiments, and that Transnet pay regiments an amount of 78 million. You see that?
Yes.
Dealt with that.
I'm sorry, did you say page 385?
385.
Okay. I've got it.
Mr. Molefe, I suppose there's one thing I haven't finalized.
Are we done with that paragraph?
I'm going to come to that. If I would just ask you to confirm, you signed the memorandum you received from Mr. Singh the next day?
Yes.
On the 17th of April?
Yes.
Yes, do you want to comment on 259?
It doesn't have the context that I put here
Yes, sure.
to say that 78.4 million was in recognition of the fact that they had saved us 2.8 billion rand.
Yes.
So the 78.4 million rand on its own, naked like this, looks like a lot of money. It looks like unreasonable. And it would surprise people with untrained eye like M&S. But if they had put it in context, it might have not surprised them.
All right.
So that is the comment that I want to make, that it's actually misleading because it does not put everything in its proper context.
What M&S then do at paragraph 2.5.10 and 2.5.11 is they essentially summarize the memorandum. We needn't deal with that. But could I ask you please then to go to 2.5.13? You've confirmed that on the 17th you approved that request,
Yes.
correct? And then what they refer to is a memorandum from Mr. Edward Thomas. Do you know who he was?
No, I don't know who it was.
I understand that at a time he was the chief procurement officer.
Yeah, yes,
Might he have been?
yes. I don't remember meeting.
And it talks about a memorandum of his dated the 23rd of April. And this is what he said at paragraph 11 from the memo. The benefits that Transnet obtained from the transaction advisor contract was as a result of the contracted or deliverables being provided in terms of the current fixed fee agreement Transnet has with the service provider.
Yes,
So in other words, he's saying, well, that's what you contracted for.
yeah,
And then he goes on to say, the fact that Regiment's capital operating model is based on a risk share model or success fee is irrelevant. Regiment's capital willingly accepted the rights and obligations of an existing contract whose fees is fixed fee for the delivery of deliverables. Regiments also agreed to an increased fixed fee for the detailed deliverables that they delivered on. Next paragraph, based on the above, notwithstanding the GCE's approval, we do not agree to the implementation of the change in the remuneration model, as the service provider has been sufficiently remunerated for the services provided as per the agreement. You want to comment on that?
Mr. Mybeck, I do not know why you choose to leave out what is in the M&S report about Mr. Thomas, when he said that he wrote on the 24th of April a memorandum objecting to the revenue sharing model. He wrote a memorandum, which you are now referring to. But in the M&S report, M&S says, Mr. Thomas says that memorandum, he could not confirm that that memorandum did reach Mr. Molefe.
I'm coming to that now, Mr. Molefe.
No, but Mr. Thomas says the memorandum didn't reach me. In fact, he says it never reached Mr. Singh or myself. So, yes, he wrote that memorandum. And in fact, maybe if I had seen it at the time, I may have reconsidered the decision that I had taken. But the fact of the matter is that, and I don't know why, you are leaving paragraph 25, 2.5.15 of the M&S report, where he says Mr. E. Thomas could not confirm whether Mr. G. Peter shared the memorandum with Mr. A. Singh and Mr. B. Molefe.
And I was going to come to that, Mr. Molefe.
No, sorry, I was under the impression that you're just ignoring
No,
it.
why?
I thought you're sweeping
So
it under
let's-
the carpet.
No, of course not. But let us first deal with the sentiment expressed. I accept it records you didn't get it.
No,
What
I would prefer not to comment on Mr.
All right.
Thomas's memorandum, because it is a memorandum that never reached me, that I did not have at the time a fair chance to consider.
But what about the proposition that I want to put to you, that it was part of their deliverables that they had contracted for. That's what he's saying.
Well, the representations
Yes.
that had been made to me in the memorandum of the revenue sharing of the remuneration model was that there had been savings of 2.8 billion, and that those savings were over and above what was required to be done. So if you say to me that, well, that was part of their deliverables, then you are then suggesting that those representations to me were misrepresentations, which at the time is not something, I was not doubting anybody's bona fides at the time.
If I then take you to the next paragraph, and you're quite right. In an interview with Mr. Thomas, he confirmed that he had drafted a memorandum to Mr. Gary Peter, objecting to Regiment's payment on a risk-sharing basis. However, Mr. Thomas could not confirm whether Mr. Peter shared the memorandum with Mr. Singh or Mr. Malefe. As I stand, your evidence...
I would have preferred that you start there. Say that Mr. Thomas did write the memo, but that memo did not go anywhere. And that for whatever reasons, it didn't go anywhere. It never came to the attention of Mr. Malefe. However, Mr. Thomas feels that the payment was not necessary.
And what is your view of that? Now, seeing this, seeing the concern that he raised.
No, Chairperson, I can only talk about what happened at the time. What I feel now, I mean, I feel that perhaps if I had seen Mr. Thomas's memorandum, I may have reconsidered, but I didn't. And the objective facts are that I didn't, and that I, at the time, was convinced that the payment of 70.8.4 million was justified.
What position did Mr. Peter occupy at this time?
Mr. Peter was very senior, more senior than Mr. I suspect Mr. Peter was Mr. Thomas's boss. Yes, Mr. Peter was in the finance department, I think, not responsible for procurement, but responsible for, I can't remember the terminology now. But,
Treasury?
No,
Not treasury.
I remember now. Supply chain, no, I'm not sure. But he was in the procurement space. He put together the procurement transaction.
And if Mr. Thomas had written this memorandum to him, would you have expected Mr. Peter to provide you with the memorandum?
Well, it depends on to who the memorandum was addressed. If it was addressed to me by Mr. Thomas with the intention that it should go through the different levels until it reaches me, I would have expected it to reach me. But if it was a memorandum that he just addressed to Mr. Peter, then perhaps the fact that it didn't reach me should not surprise anyone.
All right.
I'm not sure. Who was it that was addressed to?
I beg your pardon?
Who was it addressed to?
I can find that out for you. On the reading of it, it seems to me it was addressed to Mr. Peter.
Yes.
So as I understand what your evidence is that if it was one of those multi-level
Yes.
memos, it would have
Yes.
got to you. But otherwise, as I understand your evidence, correct me if I'm wrong, it would have been up to Mr. Peter to decide.
The way the system worked, if Mr. Thomas wanted to bring anything to my attention, he had to write a memo to Mr. Molefe. And at the bottom, say that I've compiled this memo, and these are the issues in the memo, recommendation, and so on. It would go to his boss. His boss was not obliged to agree with him, but he was obliged to pass it on to Mr. Singh and then to myself. And so it would arrive at me with memo compiled by Mr. Thomas, not recommended by Mr. Peter, not recommended by Mr. Singh, but nevertheless brought to me, to my attention. It was addressed.
And then if we just carry on, there's just, I think, two other points I want to look at. 2.5.16, on 24 April 2014, Transnet and Regiments concluded the first addendum to the MSA, which provided for a fixed fee of the 78 million, correct?
Yes. Now, that adds to the confusion of who signed the MSA that I referred to earlier, which is a legal conundrum that has now just come to my attention.
Yes.
Because now, Transnet and regiments conclude an addendum to the MSA, and yet the evidence was in the MNS report that the MSA was signed by McKinsey. After signing it, they sealed the transaction on a date after signing. So really my question, I'm really also flabbergasted now about how this could have passed through the legal department. Because all the agreements that we were entering into, there was a standard operating procedure that they had to be vetted by the legal department.
Yes. And what we do know,
And can I tell you something also that also flabbergasts me genuinely, is that when payments are done, for example, the payment of that 78.4 million, the finance division, before they make a payment, they have to see the agreement on which the payment is based. So my question then on reading this was, so what was used? And those things were outside of my knowledge.
all right. Well, it's those very points that you raised that are obviously also things that concern the Commission, but we needn't go through all of that. If I could just direct your attention to paragraph 2.5.18, I'll just ask you to confirm that on the 30th of April, regiments was then paid 79 million.
Yes.
And you might then have seen at paragraph 2.5.20 that MNS, having investigated the matter, found that there were in fact no savings that regiments secured for Transnet.
Well, that is news to me, because as I say, at the time of signing the memorandum, I did not trust the bona fide. I did not question the bona fides. There was nothing that would have made me to be suspicious that this is indeed not the case, what has been represented.
Of course, if any service provider says to you, please, let's revise my remuneration package, or let's revise how much you are going to pay me, because I've saved you so much.
Yes.
Before you agree to the revision, you would need to satisfy yourself that the statement that they have saved you so much is factually correct.
Yes.
Yes. So are you saying that in this particular case, you didn't do that, you accepted their word, or not
No,
really?
it was recommended internally.
Yes, okay.
So the people that had engaged with the service provider
Yes.
represented to me
Yes.
that everything is fine. However, this statement of MNS may be disputed as well. Perhaps when they come here, they will say, we don't agree with MNS, that this was indeed the case. And they will say that there were savings. All I'm saying is, the representation that was made to me was that there were savings, and I trusted the bona fides of my, the people that I work with, my colleagues, that this is in fact the case.
You didn't say to them, I guess that flows from your evidence that you accepted their bona fides. You didn't say to them, you know, this is a huge saving you're talking about. Is it 2-something billion?
2.8 billion.
Yes, huge saving. Please come and show me how that has come about. You
No,
didn't go that far.
No, I didn't, Chair. You know, my attitude was when you are a group chief executive of a company, you have to trust your colleagues. You have to trust your subordinates. So if they tell you that it is raining outside, you don't take out your hand through the window and check if it is raining.
Yeah.
And unless that trust is broken at some point. But I remember in team building, there was an exercise that we used to do where we all hold hands in one line, and everybody is blindfolded except the person in front. So you have to trust that person, even if you're walking in water. But you have to say, okay, he can see, I can't see. And that is how it works, because in a sense, from where I sit, this was not the only issue that I was dealing with, and I had to trust the people that were giving me information on this particular issue.
Mr. Maibe.
Thank you. Just so that I understand it, when you say you trusted your colleagues, are you referring here to Mr. Singh? I mean, there was
Yes.
no one else.
Yes.
Did you, when you received this memorandum, did you engage with Mr. Singh?
I think we may have had a discussion one-on-one where I asked him to take me through the memorandum and explain to me what it is about. And he did. And then I was it.
You may have.
I may have, yes. But that is not recorded anywhere. And, but I seem to recall that we did that I said, Anoj, what is this about? And then came into my office and said, explained, took me through the memorandum point by point and said they have saved us 2.8 billion.
Did he?
And then,
In the process of doing that, did he indicate to you when the McKinsey MSA was signed and
no,
when there was a
I don't
session?
remember. No,
Did
I
he
don't
bring all
remember
of that to your
where
attention?
they discussed the discussion. I just wanted to understand why we are paying Regiment 78 million.
So let's go back to the M&S memo. And just, I don't know if you know this, you know that Mr. Sedumeni, the author of this, when I say memo, the report, has testified in the commission.
Who?
Mr. Sedumeni.
Sidumedi,
Yeah. You know that he's testified.
Yes, he's testified. And I was forced to take both their report and as well as their testimony here with just a little bit more than a tablespoon of salt when it emerged in the press that in fact they were possibly involved in a bribe as M&S. And although the press ombudsman had ruled that there was no substance to the allegation, the press ombudsman did publish a conversation between one of their partners and somebody at Transnet where they were talking about the payment of what appeared to be a bribe. And so even now when I read this report, I read it in that context that these were possibly people that were not objective.
Right? If we go back to paragraph 2.5.20, there were no savings that Regiment secured with Transnet in that one, JP Morgan hedged the financial risk that Regiment's purports had derived, significant savings for Transnet. 2, the idea to transfer the FX risk to the balance sheet of the suppliers came from Transnet and not Regiments. And 3, the performance guarantees did not result in savings due to the small amounts used, and the majority of the bonds were market-related. As I understand it, you say you didn't, or perhaps I could just ask you to comment.
Yes, I can comment on that. And perhaps the people that had written the memo that has an opposing view to this, if they come here, perhaps they'll give evidence to the extent that this is not correct. But like I say, coming from M&S, tablespoon of salt.
You yourself don't know whether that saving was affected, as I understand your evidence.
No, I know it to the extent that it was represented
It was told to you,
me.
yes.
So,
Well, I understand that answer to be saying you don't know as a matter of fact, but you were told by somebody you trusted that there were such savings and you accepted.
yes, and,
Yeah.
and over and above that, Chair, I trusted that we have quite a robust internal audit and what I considered to be a robust legal department. and that it was not possible for something like this to land up on my desk. That was not correct.
Well, I just wanted to ask you, I mean, you see that on this memorandum, there are not various levels of authority. Mr. Singh is writing directly to you.
Yes.
Is that right?
Yes.
And is my understanding of your evidence correct, that you didn't ever have an occasion to question Mr. Singh's trustworthiness?
No. No. It could have been drafted by somebody for Mr. Singh that didn't put their name. It did not reflect that it had been recommended by anyone else, but the fact that Mr. Singh had recommended it was sufficient for me. In any way, if it came to me with Mr. Singh's recommendation, and that is what I looked at.
So we started out yesterday dealing with the procurement of consulting and advisory services. And so far what we've been dealing with really is the 1064 advisory contract. I want to change to another topic, albeit related, but it's the next contract that I want to look at. And that is the China Development Bank loan.
CDB loan, yes.
Now, let me perhaps just summarize, Mr. Malefe, some of the evidence so that I can get you to the point where you and I can engage one another about what I'd like to ask you. What the evidence shows is that after the 1064 Locomotive contract was awarded to the 4 OMEs, Transnet, of course,
Or OEMs.
OEMs, I beg your pardon. Transnet needed to secure funding for this about 50 billion rand expenditure.
Yes.
And the two Chinese bidders, CSR and CNR, they had included letters of funding support from the Chinese Development Bank. And that's what brings me to this topic.
Yes.
Now, Ms. Makato, she was...
Makato.
Makato.
Yes.
She was your head of treasury, is that right?
Yes.
She gave evidence about a trip that she took to Beijing with Mr. Singh in July of 2014 to meet the Chinese Development Bank. And she went on to testify that upon her return from Europe, because she did some international traveling then, at the end of July 2014, her evidence was that she was shocked to find out that regiments were on the scene and negotiating with Chinese Development Bank.
Yes.
That's the rough background.
We're in China.
No, when she
When
came
she
back.
returned, when she returned, yes.
And that then brings us to the 4th of August 2014, when she sent you a memorandum
Yes.
setting out her concerns.
Yes.
Perhaps I could take you to that memorandum, and let me take you, please, to, just give me a second. Could I ask you, please, to fish out Exhibit BB10, little a?
Yes.
Could I ask you, please, to turn to page 31. MEM 31.
Yes.
So at paragraph 126, she talks about returning from Europe, and she was shocked to find out that the CDB was now communicating directly with regiments and that Eric Wood was leading the negotiations. This was in parallel to Transnet furthering negotiations with the CBD. I just wanted to then take you to paragraph 127 over the page. She said, I again complained bitterly to both Anoj Singh and Brian Malefe, as I believe there was no need to use regiments because of our internal treasury capacity. She refers there to Annexure MM6, that you find at page MEM 75. You want to go there?
Yes.
And you accept that you received that email from her on the 4th of August?
Yes.
She goes on to say in her affidavit, at paragraph 131, this is at page MEM 33,
Yes.
that you organized a meeting between Transnet and regiments to resolve the CDB pricing proposal impasse. And that meeting was held, she says, at the Melrose Arch Hotel. Transnet was represented by Mr. Singh and yourself and herself, and regiments by Eric Wood and Niven Pillay. You confirm that?
Yes.
She says that Brian Malefe suggested that as everyone seemed to think that my pricing indication is off the mark and the one that Eric Wood received from Nedbank seems reasonable, I should agree with them, as I was the only one who did not agree. I told Brian Malefe that my position has not changed and will not change, as the CDB facility is expensive and not worth it.
Yes.
You want to comment on that?
Again, Mr. Myburn, you started the story right in the middle and went to the end to paint a particular picture.
You're stuck in the middle, did you say?
You started it.
Oh, I beg your pardon.
Yes. I don't know for what end. But the story is that there was ongoing disagreements between Matane Makhato and Anoj Singh. Matane Makhato and I had worked at the Treasury. He reported to me at the Treasury when I was a Deputy Director General, Assets and
You say she reported to you at National Treasury?
Yes.
Yes.
When I was Deputy Director General, Assets and Liability Management, she was Chief Director responsible for foreign funding. I have huge respect and knowledge of the international capital market, as well as risk management and structuring, and the bond market generally. Her knowledge is very superior. She came to me to complain before this incident, about 2 times before, about Eric Wood and Anoj Singh and their proposal. And on both occasions, I said to her, okay, I hear you, I will deal with it. And on both occasions, I followed her advice. I did not do what Anoj Singh and Eric Wood had been proposing. But when it came to this, there was a big debate. I saw Matani separately, and I saw Anoj separately. And they both presented their case. Hey, when you're doing a transaction like this, there are numerous views about how to approach it. And Matani had a view. Anoj had a view. And Anoj, the advisors that were advising Anoj on the transaction were Eric Wood and Niven Pillay. And my feeling about that was that let 1,000 ideas, flowers bloom, let's get more ideas. There's no harm in getting different perspectives. And Matani disagreed bitterly with it. And instead of just dismissing what she was saying, I called a meeting, which happened to have happened at Melrose Arch. So I said to her, let's go to a meeting with her, and let's have a debate on this, right? So there was a debate, as she correctly points out, that they were feeling, they felt that what they were presenting would be the best solution. And in the debate, she could not sway them to agree to her position. I actually understood her position and sympathized with her position. But I then said at the end of the meeting, Matani, since you're the only one holding this position, because I excluded myself, because I wanted to be like Abby. Since you're the only one.
You wanted to be like a judge.
I wanted to be like you, Chairman. Since you're the only one who is holding this position, are you prepared to say that their position, which is held by these three, is something that you could go along with? She said, no, I will not do it. I will not agree to it. I did not say you must go with it. I said, would you be prepared to consider going along with this idea that they are proposing? And she said, no, Chairperson. And after she said no, because I respected her immensely, I never implemented it, despite the fact that the three gentlemen had a position. I never implemented it.
All right. And then what we know at paragraph 133 is that after that Melrose Arch meeting, she then sent you...
I'm sorry, you referred to what paragraph?
Paragraph 133
Okay.
at MEM 33. Are you there, Mr. Malefe?
Yeah.
She says she sent you a further email. Perhaps you can go to that.
Yes.
At page 240.
Yes.
I'm not going to take you through this, but she put forward her position in some detail, correct?
Yes, yes.
And in fact, in the introductory paragraph, after I trusted you well, etc., it says, for the avoidance of doubt, I'll bring the following to your attention. And then she sought to emphasize points under the heading overall governance,
Yes.
fees, interest expenses,
Yes.
once-off arrangement fee, because of course there was a fee to be paid for this. That fee would go to regiments. And then under the heading conclusion, she said, it's my belief, this is at page 242.1, it's my belief that the CBD facility in its current form is not in the best interests of the company or the country, given potential capital leakage of up to 3.7 billion in excessive interest expenses and excessive arrangement fees, which may be classified as a PFMA violation given the information at our disposal. So that was her view.
That was her view. And
There was another view held by Mr. Singh, as you've said.
yes, the only thing that I did not do, and which maybe may have resulted in being misunderstood, was that I never chastised Mr. Singh in front of Ms. Makhat.
Just repeat that.
I never chastised Mr. Singh in front of Ms. Makhat. So I never, in the presence of both, said to Mr. Singh, you're wrong and she's right. And even when she came to me, I never spoke bad about Mr. Singh, because Mr. Singh was her boss. He was her superior. And what the advice that I gave to Mr. Singh is that you must take the disagreements from your staff very seriously, listen to them, and please, I don't want this thing, that your staff is disagreeing with you, and you are having to come to me on positions where your staff disagrees with you. This was a private conversation that I had with Mr. Singh. Please make sure that you sort out your house so that when you come to me, you come with one position. But because of this agreement, Matani's concerns, none of the structures that came, that she objected to, was implemented at Transnet.
All right, and then if you have a look at paragraph 135, it reflects that Mr. Singh then wrote a memorandum in response. Can I ask you just to...
That's just to say 135 at MEM 33.
Yes, thank you, Chairperson. That memorandum you find at MEM 285. Could you go there, please?
285.
285, yes.
Yes.
And this, I'd ask you to confirm, is Mr. Singh's response, correct?
Yes, yes.
He puts forward his case, and if you go to MEM 287,
Yes.
you will see that what he asks you to recommend is it's recommended that the group chief executive approve the response to the group treasurer for issues raised on the USD 2.5 billion loan facility with China Development Bank. So he wanted
Yes,
you to...
so he wanted me to take a side.
Yes.
Yeah, so I did not approve
That's why you
anything.
noted it.
I just noted that that is his position.
So if you go to paragraph 136, again,
Yes.
at page MEM 33,
Yes.
you'll see there at the foot of the page, Ms. Makato said, I find Brian Malefe's response of noted instead of approved, as per paragraph 5 of the memorandum, interesting. It was confirmed to me that Brian Malefe considered my analysis and conclusion that approximately 3.7 billion could be wasted costs had merit. Do you want to comment on that?
Actually, she's also not correct. I did not take a side. That was what my noted meant. I did not take a side, so my saying noted, I was not taking a side because my advice to Anoj has always been, go and discuss with your people and come with one position. So the fact that, so if I had said in that memorandum, not approved, which means that I'm taking Matani's side. I think as a manager it would be wrong because it would be taking a side of a junior person against their superior. That is a recipe for disaster. So even if you agree, you have to get them to come to one position at some point.
Well, I would imagine that I would imagine it would depend what regime you have in the organization. Do you have a regime that says the CFO must have a discussion with his or her staff on matters that must come to you, and as the head of that department, he must then give you his view. And if he chooses to let you know that there is a view different from his, in his department, he must know he is taking the risk that now that you are told about this other view, you might find it attractive. And if it is the correct view, I would expect that you shouldn't be prevented from taking the correct view just because it might hurt the ego of the head of department. But another regime might be, you are the head of the department, you bring to me the outcome of your discussion with your staff. And that the regime might mean there might be disagreements within his staff, but he must take a view, and that's the view that comes to the group
Yes.
CEO.
Yeah.
Would you agree with that?
Except that it's not called regime in the literature. It's style, management style. It's management style. So my management style is collaborative. Collaborative. Collaborative means you do not suppress views, irrespective of from how junior the person making them. But while you do not suppress views, you acknowledge that the executives that these people report to have, if you like, egos, and that you have to find a way of accepting a view from a subordinate in a manner that does not create tensions in the organization with the superior. So it must be collaborative. And I didn't care how long it took. I had resolved that they have to find each other
Yeah.
and come with a common position.
Yeah.
They have to find each other.
And they did not find each other.
And they were not finding each other.
And then you decided, look, I won't say this one is right, this one is wrong.
Yeah, and we did not implement
Yeah, you did not implement
any
that
of
as
the
well.
propositions.
Yeah,
I agree that at some point I would have had to make a decision.
yes.
But I felt that that point had not
Had
arrived.
not been
We were not
reached.
in a crisis.
Yeah,
Yeah, so it had to be collaborative.
no, I understand.
And so, yeah, in fact, when you read through her affidavit, you will see that there were tensions. There were tensions. I was
Yeah.
sensitive to that.
Yeah,
But I must repeat, Chair, that I did respect Ms. Makatu's views.
yeah,
It's just that the situation that if she had been reporting to me and came with those structures,
yeah,
and I would also, and one of her subordinates had disagreed with her, I would have asked her to go back
yes.
until there is a consensus.
Yeah,
Yes.
okay, no,
Yeah.
that's fine. Then my
So,
bad.
thank you. Mr. Molefe, that I think takes us to the 28th of August 2014, when you noted the memo. So you've got these two conflicting views.
Yes.
What we do know is that an agreement was concluded with China Development Bank on the 4th of June 2015, but by this time, as I would just ask you to confirm, you had been seconded to ESCOM, is that correct?
Yes. Yes, Chair.
And-
yeah, I won't express an opinion on that agreement, but yeah, after I had left, then it went in a particular direction.
I'll just ask you if you go, please, to page MEM 34.
Yes.
Ms. Makato then carries on with the chronology. She talks about a presentation made by Mr. Singh, and then at paragraph 140 over the page at MEM 35, she says, pursuant to Anoj Singh's representation to the board, the attached CDB term facility agreement was signed on 4 June, committing Transnet to a very expensive loan agreement. Seems to have maintained her view. But by that time, as you say, you have left.
I had left, and perhaps it is up to the board and Mr. Singh and the people that signed that agreement to come and put their case
Yes.
as to why they thought it was in the interest of the company.
But as you say, you never, in the course of your term, put a stop to the potential regiments.
No, this one, I didn't see it as a regiment thing. Yes. I saw it as a disagreement by professionals
Yes.
on how to structure a particular law with the China Development Bank. And I also acknowledged that the China Development Bank, you see, Ms. Makato and myself, we did transactions for the National Treasury. We funded the fiscal on international capital markets and domestic capital markets. But we always funded the fiscal from loans sourced from the Western world, from Europe, from the United States. Sometimes we ventured into Canada, and then we did Japanese loans. There we were very good. We understood how that worked. The US financial markets, the bond markets, the institutions in the US, how they work. When I went to China to have a meeting with the CDB, I discovered that actually they work very different. And even as I was leaving the treasury, sourcing funds from China was a new thing. There were several markets that were very different from what we were used to. One of them was China. The other one was Sukuk, which is the Islamic, I think it's the Islamic loans with no interest. So we were exploring these as, I don't want to use the word exotic, but as alternative sources of funding, but that are very different from what we're used to. So even in this disagreement, I was aware that, well, you know, part of the problem is that the CDB operates slightly differently from the multilateral institutions in the Western world.
So, Mr. Molefe, you've read, no doubt, that regiments were paid 166 million as a success fee for securing the CBD funding facility and their advice to split the capital raising between CBD and the so-called ZAR club loan. Have you read about the fact that they got
Is this after
the
I had
success
left?
fee? Yes. Have you read about that?
Not particularly. I mean, I never looked back at what was happening, but in the context of the commission, yes, it would appear that that is what happened. But when I had left Transnet, I did not try and do anything from the grave.
Yeah. And certainly on the money flow analysis, half of that money would have found its way into a process of money laundering. But as I understand it, your case is you don't know about it.
Yes.
All right.
Yes, I can't comment.
Mr. Mohammadi, in
Yes.
addition to Ms. Makato, also gave evidence about this loan.
Yeah.
And his evidence was to the effect that Treasury had sufficient expertise to enter into the loan transaction. He was of the view that there was no need for external support and that there was no need for the loan agreement fees to have been incurred,
Yes.
the arrangement fees.
Yes.
Do you recall that evidence?
Yes.
You want to comment on that?
On reflection, Chair, after, I think that perhaps where I failed, Ms. Makan, maybe what I should have said to her was, when we go to the meeting at Melrose Arch, bring 2 people with you that agree with you. Because then she can now argue that it was loaded against her. Maybe she felt that way, although that was not the intention. The intention was to have a mature adult debate about this law. But perhaps on reflection and on reading Mr. Mohammedi's comments, I felt that perhaps I should have asked her to bring two people that agree with her so that we can have a proper debate. That did not, unfortunately, happen. But yes, it's one of the regrets that I have. Maybe that is what I should have allowed to happen at the time. However, the disadvantage of that is that Mr. Mohammedi worked in the treasury and was reporting to Ms. Mahat. So that would have, been bringing two people that are 2 or 3 levels below Mr. Singh to come and argue with him. Sometimes that does not yield. Ms. Makhatu is assertive. She would have stood her ground. But yeah, maybe I should have said she can bring 2 people. But then at the same time, sometimes people, when the GC is present, the CFO and the treasurer, and there is an argument, they either just freeze and keep quiet. They don't want to take sides against any one of those people, because, yeah, which is another reason why I feel that the evidence that you get from people that are still at Transnet and ESCO, you must treat it in that context, Chair, that they feel like if they don't say what they think the Commission wants to hear, they may lose their job. I'm aware that there are a lot of people that are seen as Brian Molefe people that were summarily disciplined and dismissed because they were, and those people have not done anything really. They were very professional people. Unfortunately, they left. They had to leave because I had been tainted by the public protector as somebody who was potentially corrupt. And so it had a ripple effect on innocent people whose mission in life was just to look after their families.
So could I just ask you, do you agree or disagree with Mr. Mohammedi's view that he gave here before the Commission?
What was his view again?
Well, it was simply that there was no need to incur the loan arrangement fees paid to regiments.
No, I can't comment on it, Chair,
All right.
because it's a debate that happened after my.
All right. And perhaps, just to conclude this, I will just put to you what he said in evidence that he gave on day 93, and this you find at page 144 of the transcript. He said, "The only possible plausible explanation from my perspective would be that there was an agenda for payment to be made to regiments ultimately, or some entity that existed outside of the system."
He said it here in the Commission.
Yes.
Yeah, I've experienced how the Commission can want to make you say things that you feel at some point you're compelled to say just to get out of the situation. Unfortunately, it is not all of us that are assertive. So I would say that, especially if he's still working at Transnet, coming across a person like Mr. Maibek, who says, you knew, and he knows that this could mean that he's going to lose his job, then he's bound to say anything. So I would take what he said with, well, not a tablespoon, just a pinch of salt, and say that and say that be careful to interpret that as an honest statement. We don't know what his real honest statement would have been if you remove the circumstances that he finds himself in.
And do you feel comfortable saying that, despite the fact that this was an agreement concluded after your time?
Saying what?
What you've just said about Mr. Mohammedi.
Yeah, I'm just saying that Mr. Mohammedi may have been influenced by other factors to say that.
see.
Yes, so it may well be his true feeling, but I'm just saying discount it and know that, I know that there are a lot of people that have come here and said things that I know they would normally not say, other than the fact. It's like, they call it a fish pond thing. It's like a fish in a pond that is aware that it is being watched, behaves differently from fish that is just swimming at sea.
So that I understand it, you were issued with a lot of 3-3 notices in
Yes.
this case, correct?
Yes.
And never once did you exercise your right to put in a statement opposing what people said, correct?
Yes.
And never once did you exercise your right to cross-examine anybody.
Yes.
Okay.
Because you want to know why?
You can go ahead, Mr.
Because actually, going through those 3-3 notices, I can't recall, I may be wrong, but I can't recall anyone implicating me in wrongdoing. In wrongdoing. None of them implicated me in wrongdoing. And this morning when I came in here, I was listening to an application to cross-examine, and I was listening to the criteria that the chairperson was using, that the chairperson is in a hurry to finish. So if nobody has implicated me in wrongdoing, there was really no need for me to come and waste chairperson's time. There was just once that I got an instruction from the chairperson to respond to Mr. Jabu Mabuza. Mr. Jabu Mabuza, who did not know what he was talking about, who had no idea what had been happening there. And I responded to his, I think it's a section 10 something notice that I got.
10.6 directive.
It was a 10.6 directive, yeah.
Yeah,
The only
regulation
10.6 directive was Mr. Mabuza. It was very surprising because Mr. Mabuza's evidence was things like, yeah, Mr. Molefe has skills, but he was using his skills for other things. I mean, that is not an implication of wrongdoing, number one. Number two, he did not provide any evidence.
Well,
My response, the affidavit that I submitted was very, very brief. And I never had anything from the commission after that. Even when we were in my
on ESCOM.
on the ESCOM evidence, his evidence was not referred to at all, just like Tulima Donsela's evidence was not referred to in the ESCOM.
So do I understand your case?
So nobody, I can't recall that anybody implicated me in wrongdoing.
Do I understand you to be saying that as you sit here now, you don't feel that you've been implicated at all in any wrong? And it's different between being guilty of wrong. Is your sense that you haven't even been implicated in wrongdoing by anybody?
I can't recall. Maybe you can.
You received all the 3-3s.
I can't recall that any one of them implicated me in wrongdoing. Yeah, they talked about me. I mean, I got a 3-3 relating to Mr. Pravin Gordon, who said that Mr. Brian Molefe thought that the nuclear deal could be funded. Of course I did. And there's nothing wrong with that. It could be funded. He had to be corrected by Mr. Pretorius in this room, saying, Mr. Gordon, in fairness, the engineering news has indicated how Mr. Molefe says the nuclear deal can be funded in an interview with Mr. Molefe. And Mr. Gordon's response was, yeah, but you must remember that Mr. Brian Molefe is highly trained by us, and he understands these things. And so I don't see why that was wrongdoing, why I had to get a 3.3 notice that says that Mr. Gordon says, you think the nuclear deal can be funded. Guess what? A couple of weeks later, maybe months, new Minister of Energy is appointed. First thing that he says is, the future of this country is nuclear. Where's
Well,
Mr.
I just
Gordon?
want to say, must have been in the other venue where Mr. Pretorius would have been leading the evidence of.
No, when I say in this room, I mean like in
In
this...
the commission.
Yeah, in this home.
Yeah.
Yeah, this home is not the house. It's the,
Yeah,
it's the
yeah.
people that are... Yes.
Yeah.
Mr. Chairperson, I see that it is 1 o'clock. If this is a convenient time.
Yes. Okay, I think let's take the lunch break. We'll resume at 2 o'clock. We adjourn. Okay, let's continue.
Thank you, Chair. Mr. Malefe,
Maybe you could move your mic towards you a little bit. Yeah.
thank you.
Okay.
Before lunch, we were dealing with the China Development Bank loan. I'd wrapped up on that, but I just wanted to ask you this. Did I understand your evidence to be that generally when it came to Mr. Singh and Ms. Makato, that you didn't take sides or choose one above the other?
Look, I mean, I can't be categoric in answering that question or be absolute. But generally, as a matter of style, I prefer to be collaborative.
All right. Could I perhaps, in that regard, ask you to turn to page 18, MEM 18? So that's exhibit BB10, Ms. Makato's exhibit. I want to ask you a few questions in that context around the so-called 5 billion rand proposal that she deals with in her affidavit.
What is the page number?
MEM 18. Mr. Chairperson, in exhibit BB10 little a. Now, if I could direct your attention to paragraph 68. Now, I'm not going to deal with the whole paragraph. I'm just going to use the first sentence to locate us in time. She says at paragraph 68 that my concerns about regiment started in 2013. One day in 2013, I cannot remember the exact date, but I believe it was in the third quarter of 2013, and she goes on to say she received a call. Could I ask you then to turn over the page to page MM19, and for us to pick up at paragraph 71.
Mr. Mybeck, you appear to, or sound like you're saying MM each time.
I beg your pardon,
MEM.
MEM, and it's important because,
Yeah.
of course, MM is Mr. Mohammadi. I do beg your pardon.
Yes, yes.
MEM 19. Are you there, Mr.
Yes.
Malefe? At paragraph 71, she says, the following day, that's after that telephonic discussion, it was a day where I had two important meetings, FinCo and CAPIC. These were monthly meetings with FinCo scheduled in the morning from 9 to 1 and CAPIC in the afternoon from 2 to 5. These two committees or subcommittees of EXCO are responsible for finance and capital expenditure matters. On that day, Anoj Singh came to me, or gave me, I beg your pardon, a funding proposal from regiments in hard copy. And he informed me that it was a very important matter that Brian Malefe needed executed speedily. He said that I should excuse myself from attending FinCo and CAPIC and rather spend the day working on this urgent proposal and draft a memo recommending the proposal for his signature and approval by Brian Malefe. You see that?
Yes.
You want to comment on that?
I can't recall that I had needed a structure to be executed urgently.
She goes on to say at paragraph 72, the regiment's proposal was that regiments will facilitate a 5-year, 5 billion rand loan facility that was to be funded by Nedbank. You see that?
Yes.
Does that jog your memory at all?
Say the regiments will facilitate a 5-year, 5 billion rand loan.
Yeah.
Yes.
Sorry?
No, what I couldn't recall was that I had said it must be executed urgently.
Urgently, all right.
Yes.
So if we could go then over the page to MEM 20, paragraph 73. The proposed facility was priced much higher than normal facilities or similar loan facilities or domestic bonds. My calculation indicated that Transnet would have to pay an additional 150 million per annum in interest payments over and above what Transnet normally pays for similar facilities. This translated into potential losses of 750 million over a 5-year period. I shared my analysis with Anoj Singh and indicated that I do not recommend the proposal given potential excessive costs in interest payments.
Yes.
He responded saying that it is an instruction from Brian Malefe and that I should quickly complete the memorandum for approval the same day.
No, I don't recall that there was such an instruction for myself.
She says in the next paragraph, I felt very uncomfortable with the same day approval request, as we have never rushed funding initiatives before, and definitely not same day, especially given the potential losses of 750 million over a 5-year period.
Yes.
75, paragraph 75, I decided to discuss the matter directly with Brian Malefe and went to his office. I told him that I understood that he expects me to urgently recommend a 5 billion rand 5-year loan that Regiments is proposing, wherein 150 million would be unnecessarily incurred per annum, accumulating to 750 million over a 5-year period, with no clear benefits for Transnet. I was irate at that time that I explicitly told him that should we approve the structure, we will go to jail for stealing money, as we are the custodians of Transnet's funds. Do you recall that?
I do, but I wish you could jump to paragraph 83 and just leave all the drama and go to paragraph 83.
Mr. Malefe, I'm going to come to paragraph 83 if you would like to.
Oh, okay.
But let me first deal with paragraph 75. Do you have any comment on it?
No, no comment.
But do you remember this meeting where she said, if we recommend this, if we do this, we're going to go to jail for stealing money?
Yes, I remember that discussion.
So you do remember that?
Yes.
So had you given the instruction that this funding proposal be completed and signed off in one day?
Which is why I was asking you to go to paragraph 83 and leave all the drama.
Okay. So let's then go to 76. The structure was overpriced. We have a direct relationship with Nedbank. There was no need to use a conduit like Regiments to engage with Nedbank. Brian Malefe agreed with me and said that he will handle the matter. The structure was never implemented. Would you agree with that?
Yes.
Well, I just wanted to say, Mr. Malefe, sometimes the drama is necessary so that one has a good picture of how the atmosphere was in that room as something was being discussed. So I just wanted to say sometimes one needs it, sometimes not.
Yes,
Okay.
Chair, the bottom line is that I agreed with her. And
Yes.
the structure was never implemented.
Yeah, okay.
But of course, the question arises is how could you ever have required Ms. Makato to sign off on this in one day, firstly?
I just
and
said
sorry,
I-
if you let me finish. And secondly, on this version, how possibly could you have sought to endorse this type of proposal?
I've said to you, I have no recollection of asking anyone to implement a structure in one day. I'm not sure where this
To
evidence
prepare,
comes
to
from.
prepare rather than to implement, you mean?
Come again?
You say you have no recollection of having instructed anyone to prepare the memorandum in one day.
In one day, yes.
Yeah. And I'm just mentioning because you said implement in one day. So, but I'm saying you meant prepare in one day.
Yes, to execute. I mean, this was a request to execute in one day.
Oh, okay, as opposed to preparing a memorandum in one day.
I don't know, my understanding
thought it
is
was
that
the
it's prepare the
preparation of the
memorandum and
memorandum.
execute.
No, I may be mistaken. I thought it was just the preparation of the memorandum.
Perhaps it is myself who's maybe mistaken, Chair, but my recollection is that she came to my office.
Well, I see in paragraph 74 of her affidavit that she talks about, in brackets, same day approval. So the approval was to be on the same day, I think.
Yes.
Yeah, okay.
So you don't have any recollection of that?
No.
This was a
But
proposal.
I do note that she does say that I said to her that the structure should not be supported.
that's not an answer to what I'm probing with you, if you don't mind. This was a regiment's proposal, is that right?
Was it?
Well, she says at 72, the regiment's proposal was that regiments will facilitate a 5-year, 5 billion rand
Yes,
loan.
yes. Her evidence says it was regiment's proposal.
And what would their arrangement fee typically have been on?
I don't recall, Chair.
Yes, I'm asking you, typically, what would it have been for a loan like this? You dealt with regiments and McKinsey in other contexts, like we've been through.
No, it depends on what it is.
Are you able to give us any insight from the position of Group Chief Executive? What sort of transaction arrangement fee would you have expected regiments to levy for this sort of loan facility?
So the capital amount, the capital amount is at 750 million, maybe maximum 2 basis points.
And how much would that have translated into?
2 basis points is 0.002%.
Yes. So
Times 750, 35 million, thereabouts.
right? And the other thing I wanted to indicate to you, how could you, I mean, I think you accept that what you dispute is you didn't require this to be done in a day, but you were effectively looking to implement this loan agreement.
No,
Is
I
she
wasn't.
wrong? Is she wrong when she says that?
Yes.
Oh.
Maybe that is the impression that was created
Right.
for her, to her. I remember her bursting into my office and say, this cannot be done, and so on and so forth. And I said, what is it? And then she explained to me. And I said, don't worry, I will not support that structure.
But Mr. Singh's evidence is it's what you wanted. Or, sorry,
This
her
is her-
version of what Mr. Singh says is that it's something that you
and I
want.
say, I don't recall asking
Well-
for anything like that.
Yeah, well, I wanted to say, I think his position in relation to the proposal being completed in 1 day or executed on day was he couldn't remember whether he gave such an instruction or not. Is that correct?
Yes, yes.
Yeah.
Well,
Okay.
yes, yes.
Now that I understand, but was it still your proposal? I understand that
No,
you
it
didn't.
it wasn't my proposal.
So insofar as she's saying that Mr. Singh told her that we would suppose we'd have to canvass with Mr. Singh.
We have to canvass with Mr. Singh.
This paints you in a very potentially a bad light, doesn't it?
No, it doesn't.
Doesn't it?
No, no, it doesn't.
So
It would if I had said to her, we must do it.
I was just wondering why you never put in a statement contesting this.
Because it was never done. Paragraph 83.
But Mr. Malefe, the fact that something isn't done doesn't mean that it doesn't reflect potentially very poorly
It
on
doesn't
you.
reflect on me because I don't recall such a...
Yeah, but then why didn't you at least put in a statement to say that or something?
I deal with the evidence of Ms. Makhad
Yes.
in my affidavit. I can't recall what I say there. Well, in paragraph 69 of my statement, I say, I deny any suggestions of impropriety on my part.
Okay, so just so that I have this, because of course Mr. Singh is going to give evidence. Do you, as far as you're concerned, was this Mr. Singh's proposal?
I don't know whose proposal it was, Chair. I have no recollection of the origin or where this thing came from. All I remember is Ms. Makatu coming into my office, very irate, explaining to me what was about to happen, that there's a structure that needs to be done in one day, and saying that it's just never done. And I said, don't worry, I won't support it.
And she didn't tell you who the instruction had come from?
No. She said, Mr. Singh. She said,
Oh, see, so it was Mr. Singh.
but she said, that's her evidence.
Her evidence, when you point to that, says that Singh said it was your proposal.
Yeah.
Yeah.
It was, the person that she spoke to was Mr. Singh. I don't know what's the point of your semantics.
I beg your pardon?
I say, I don't know what is the point of your semantics.
No, it's not semantics, Mr. Leff. I'm trying
Ms.
to get to the
Makato
bottom.
spoke to Mr. Singh about this structure.
I want to simply ask you, and I'm going to move to another topic then.
Yes.
Do you understand that it was Mr. Singh's proposal? You say it wasn't your proposal. Did you understand from your interaction with Ms. Makatu that it was Mr. Singh's proposal?
Well, let me just say, I don't know whose proposal it was then.
Well, who would have the authority to make such a proposal?
I don't know. To have such a proposal, to make such a proposal. I don't know.
To ask Ms. Makatu to approve such a proposal in one day, who would have been able to give her such an instruction?
Well, Mr. Singh would, because
Anybody else?
Mr. Singh was her superior,
Would anybody else have been able?
not to my knowledge.
So on the face of it, it seemed, did you assume that it was Mr. Singh or not?
To tell you the truth, I did not apply my mind to this. It was just something that was just not going to happen in one day.
Let me just ask this to clarify. We know that in her affidavit, Ms. Makatu says that Mr. Singh came to her with
Yes.
this proposal.
Yes.
Did you get that from her affidavit or from when she was testifying? Or is the position that when she came to your office, she also said that?
No.
Namely that it was Mr. Singh who came with the proposal to her, but he had said you had given the instruction.
Well, evidence, paragraph 81, says she had lost patience with Anoj Singh and Eric Wood. So it's those two people that she had a discussion with.
No, but what I wanted to clarify is whether when she spoke to you, Ms. Makatu, in your office, when she came into your office and she was very irate, whether she did mention that it was Mr. Singh who gave her the instruction to complete or prepare the proposal.
She said she had been in a discussion with Anoj Singh and Eric Wood.
Oh, okay,
Yes.
okay.
Thank you, Chairperson. All right, I'd like to turn then to a different topic. Still under the heading of procuring consulting or advisors.
Do we keep the bundles that we were working with?
No, that bundle can be put away. If I could ask you please to retrieve Chairperson Bundle 5.
And that's the Transnet
Exhibit 22,
BB10
yes.
that goes. And then bundle 5 continues to stay? Okay.
Exhibit 22, yes, thank you.
Okay.
Now, what I'm going to deal with, Mr. Molefe, are what I refer to as the McKinsey stroke regiments consultancy contracts. Now, perhaps I could start by asking you to go to page 129 of Exhibit 22. Bundle 5, it's your exhibit.
I think it's better to always I refer to the bundle, Mr. Maybeck. because the
Bundle 5,
pagination,
Exhibit 22, page 129, Chair.
129.
Yes.
Thank you. I'd like just to draw your attention to a chronology set out. This is the first money flows report. We'll come back to it later. But it's
Yes.
paragraphs 44, 45, and 46 on page 129. You'll see that it's recorded that on 31 March 2014, Transnet decides to award the coal line contract to McKinsey and Regiments on a confinement basis without competitive bidding.
Yes.
Then on 1 April 2014, Transnet decides to award the Kumba Iron Ore contract to McKinsey and Regiments on a confinement basis without competitive bidding. And at paragraph 46, on 3 April 2014, Transnet decides to award the manganese contract and the NMPP contract to McKinsey and Regiments on a confinement basis without competitive bidding. So that is 4 contracts in the space of, seems 4 days. Is that right?
Yes.
And then if you could go to paragraph 49, that's over the page. You will see there they record that from 28 May 2014 to 24 June 2014, McKinsey and Regiments prepare bids for the coal line, Kumba Iron Ore, manganese, and NMPP contracts with Transnet. Regiments indicates that they will be using Albertine and Homex as its supplier development partners. Albertine is Mudley's company, Homex is a Gupta laundering vehicle, which is ultimately paid more than 100 million rand of the value Regiments receives under these contracts. You see that?
Yes.
And whilst we're here, perhaps I could ask you to turn to page 330 in the same bundle. And at 330, you would find the bid by McKinsey, also included Regiments, we'll see in a moment. And this related to the coal line. Do you see that? At 330.
Yes.
If I could ask you please to go forward to page 345. 345. You'll see there that there's a piece on McKinsey and Company, and then at the bottom of the page, there's a piece on Regiments. You see that? At 345.
Yes.
Then over the page to 346, there's a bullet point saying, we, that being Regiments, will subcontract consultants and services from a company advisory, Homex, and Albertine, and provide them with skills development. Do you see that?
Yes.
And then-
What is this document, by the way? Is it their bid?
Yes,
It's a bid document.
yes.
Yes.
Did you ever see this document?
No, no, I never see. Bid
And then if we go to page 350, this is a similar bid dealing with the
350 doesn't have,
yeah,
351.
350 is the cover sheet, you're right. 351 and 352, you'll see it deals with the bid in relation to NMPP. Do you see that?
Yes.
Contains the same content if you go to 361 in relation to McKinsey, and then over the page 362, you'll see this time the third bullet point under the heading Regiments Capital. We will subcontract consultants and services from companies such as a Company Advisory, Homex, and Albertine. You see that?
Yes.
So the long and the short of the money flow streams work reflects that we have 4 contracts concluded on a confinement basis in 4 days. And then there were bids submitted by McKinsey and Regiments. They indicated, did Regiments, that they would be appointing Homex and Albertine as their skill development partners. And money flows say that ultimately what happened is that Homex, the Gupta laundering vehicle, was ultimately paid more than 100 million rand from the proceeds received. You see that?
Yes.
Now, as I understand your evidence, Mr. Molefe, and I don't want to make you angry after lunch, as I understand your evidence, you say you knew nothing about this.
I never saw bid documents.
Yeah.
But do you have the contracts?
We're going to come to that now. I just want to understand, you knew nothing about, as you said repeatedly, the money laundering.
I knew nothing about?
The money laundering.
Yes.
Okay. So could I ask you, please, to go to exhibit BB 2.1, in brackets little d.
Yes.
Just give me a second, please. I want to take you to the confinements. So we have 4 contracts, 4 confinements: coal, Kumba, manganese, and NMPP. I would ask you to turn firstly to page, and these are the type page numbers, PSV 1283.
Goes on to 838.
Yeah, 1283. You may have the wrong file. So it's BB 2.1, little d. I think you may have the preceding file.
A little D for Delta.
D for Deirdre, yeah.
Well, let me make sure that I've got the right one, because I might not be having the right one. The one I have on the spine is written Transnet Exhibit BB 2.1 and small letter A.
No,
That's
you
not the
need
one.
small letter D. So Mr. Fulmink had a lot of annexures, A, B, C, and D.
Okay, all right.
I think, put differently, it's the last Fulmink file, insofar as that might help
Yeah.
your registrar.
Page. What was the page?
PSV 1283.
Okay. Thank you. Yes, I believe I've got it now.
Thank you. Mr. Malefe, do you have page 1283? All right, so this
Switch
is
on your mic, Mr. Mlefe.
So this is let's, by shorthand, the coal confinement, is that right?
Yes.
And I just want to take you to page 1289. It's recommended that the group executive approve, sub 1, the resourcing strategy and remuneration model for the coal line, and then 2, confine and award services for support to the internal team to McKinsey and Company and its BE consortium partners. You
Yes.
signed off on that, correct?
Yes, yes.
And then, perhaps just for the sake of the record, because I understand that none of this is an issue unless you tell me differently, could you please then turn to the second confinement, PSV 1291?
Yes.
And of course, on each of these confinements, you set out your grounds for confinement that we see as we page through. But the end of this is 1297, and you
Yes.
approved, again, confine and award services for support to the internal team to McKinsey and Company and its BE consortium partners, correct?
Yes.
Proposed by Mr. Singh like the previous time, or
Yes.
compiled by Mr. Singh, I suppose is the correct word,
Yes.
and approved by you.
Yes.
And then if I could ask you please to go to page PSV 1299. This is the manganese confinement. If I could ask you to fast forward to page PSV 1305. And there you will see similarly at 40.2, confining and awarding the service to support the internal team to McKinsey and Company and its BE consortium.
Yes.
That we see you approved on the 3rd of April, 2014, correct?
Yes.
And then the last contract, the NM, or the last confinement, the NMPP, that you find at PSV 1307.
Yes.
And I beg your pardon, if you would then go to the end of that contract, or that confinement rather, you find that at 1313. It's the same language at paragraph 41.2. Confine and award services for support to the internal team to McKinsey and Company, its BE consortium partners, approved by you again on the 3rd of April 2014. Is that right?
Yes.
Now, just by way of contrast, could I ask you, and we may come back to this, to go to page 1273. This is a different contract. It's not amongst the 4 that I'm dealing with now, or it's a different confinement rather, I beg your pardon. It deals with capital optimization and implementation support. Do you see that?
Yes.
PSV 1273. Are you there?
Yes.
Just by way of contrast, if I could ask you to go to page 1280, you will see that this has various levels of recommendation. There you have Mr. Mohammadi, Mr. Peter, Mr. Singh, Mr. Malefe, and also then recommended separately, it seems, by Mr. Forming. Do you see there?
Yes.
That the different type of confinement or different means, correct?
What do you mean it's a different type of confinement?
What I'm saying to you is here there are various levels of authority and recommendation, whereas in respect of the 4 confinements that I've taken you to, there we see compiled by Mr. Singh and approved by you.
Yes, but yeah, it's not a different type of confinement, it's just,
Well, it's a different, and my language is wrong, you're right. It's a different approval mechanism.
yes.
Okay. Now, Mr. Forming gave evidence about these 4 confinements that you approved. Could I ask you please to go to Exhibit BB 2.1, and you can perhaps leave that file open. I want to take you to a different exhibit, Exhibit BB 2.1, but little a. Mr. Molefe,
Yes.
2.1, little a.
Will somebody please help the witness so he doesn't have to stand and look for a file?
Could I ask you please to turn to page PSV 57?
Yes.
Mr. Forming says, and you would have seen this in the interest of time, I'm not going to take you through all of it. He deals with grounds for confinement,
Yes.
paragraphs 1 to 5 through to paragraph 131 at page PSV 60. And his evidence was that there were no proper grounds for confinement. And if I could take you to 126 at page PSV 58, he says the confinement memos rely mainly on 2 grounds, urgency, and that services are highly specialized and largely identical. And then he deals with that and he provides a criticism.
Yes.
Now, you've seen this, Mr. Molefe. What is your response to Mr. Forming?
Might be better, Mr. Mabek, if you just summarized or tell him the gist
Yes,
so the
certainly.
public can follow also when he gives an answer.
So what Mr. Forming says at 127, where urgency was invoked as a ground for confinement, the case for urgency was based on revenue-related risks and the need to deliver on the MDS. The memos further stated that if the mitigation plans were not put in place, the corporate plan, capital plan, and funding prerequisites would not be met, which would place the entire MDS at risk. However, as already indicated in Part 1 above, the PPM makes it clear that confinements will only be considered where a genuine, unforeseeable urgency has arisen. And ultimately, the point that he makes is it wasn't the submissions you see in the middle of the next paragraph over the page. The submissions do not explain why revenue risk was unforeseeable. You want to comment on that?
So the issue is urgency or the unforeseeability of revenue risk.
Must be genuine, unforeseeable urgency.
Yes.
He says the submissions do not explain why the risk was unforeseeable. Mr. Molefe, you've looked at all of this before.
Quite honest, Chair, I'm thoroughly confused. The memos that you were talking about earlier, but by the way, in BB,
Those were in little d. I think I asked you to keep that file open if you wanted.
yes. What the first one, what page was it?
That's,
1273.
yeah, the first one is, I think, at 1283. Mr. Chairman, if I may just place one thing on record.
Yes,
1283.
128.
1283. Mr. Fulming here deals with these 4 contracts.
Yes.
And he motivates why the confinement of the 4 were inappropriate. We must, however, just bring to your attention, you will recall the evidence of Deirdre Stradham. Her evidence was that she considered the confinement of the manganese contract to be appropriate. So I just don't want to be taken for misleading the witness. I need to make that qualification.
Okay.
So what's the qualification?
In respect of one of these contracts, another witness, Deirdre Stradham, gave evidence, the manganese contract, that she considered that the confinement was appropriate.
Yeah.
So, Mr. Molefe, perhaps
Sir,
we've got
if
a...
1283. And you go to page 185. And paragraph 26, dealing with the grounds for confinement. It says, appended below for ease of reference.
Sorry, what paragraph?
26.
26.
Page 125.
Yes.
Appended below for ease of reference is an extract from the current procurement procedures manual, which sets out the grounds for confinement. And it has ground A, B, C, and D. And then over the page, it says, we are of the view that this matter complies with grounds A and D, as set out below. And specific emphasis is placed on ground A and D due to the potential business risks associated with approaching the market on an open tender process, as well as the credentials listed above. And then in paragraph 28, there's a table there that sets out confinement considerations. So I'm not sure which of these in these memoranda that, or even in this memorandum, that Mr. Volmink specifically found offensive.
So do I understand you to be saying that, different to Mr. Fulming, you consider the confinements to have been properly motivated?
Yes, because I can only go with the memo
Yes.
that was presented to me, and not Mr. Volmink's subsequent interpretation.
So it was a memo
So-
presented to you.
Yes, the memo presented to me has grounds for confinement, paragraph 25 to 29. So I wonder if there is any of these paragraphs that Mr. Volming considered offensive.
Well, I think what he's saying is he doesn't believe that the requirements for confinement were met. As I understand you to be saying, well, if you look at the memo, what was presented to me was a memo where on the face of it, those requirements had been met.
Yes, because it states out what are the grounds for confinement. It actually quotes ad verbatim the procurement procedure manual, and then it says which of the grounds in the procurement procedure manual are applicable,
All right.
which is A and D, and then it goes on to take the grounds for confinement as per the procurement procedure manual, and then gives in tabular form the confinement considerations. I mean, I can go through everything and read it
All right.
as it is in the memo.
Could I take you, please, you have Mr. Forming's affidavit still open there?
Yes.
So this is exhibit BB 2.1 little a. Would you go to page PSV 63?
63.
Yeah.
63. Yes.
You're in the wrong file, Mr. Malefe. 2.1 little a. Is it not that one that you have in front of you?
Yes.
Can I direct your attention to paragraph 43 under the heading Confidential Confinements?
143.
143, yes. At
Yes.
page PSV 63. Are you there?
Yes.
Says, because of the potential for abuse of the confinement process, the PPM introduced multiple levels of review and control to serve as safeguards. First, the end user department and the operating division's chief procurement officer had to submit the request for confinement to the OD's Divisional Acquisition Council and the OD's CEO for prior written support. If the request for confinement was poorly motivated, the submission would be sent back for remotivation. The submission would be sent to group for sign-off only if it was supported at OD level. He goes on to say at 144, at group level, the submission had to be reviewed by the Group Chief Supply Chain Officer, the GCSCO, and the Group Chief Finance Officer, CFO. The practice at Group was that confinements were first sent to the SCM governance for review before they were signed off by the GCSCO and the GCFO.
Yes.
Over the page, PSV 64, paragraph 145, if the GCSCO and the GCFO supported the confinement, it would be submitted to the GCE, the BADC, or the board itself for final approval, depending on the value of the transaction. The process for the approval of confinements is more fully described, etc. At paragraph 146, these levels of review were introduced as safeguards to ensure that confinement submissions were subjected to a robust review before they were submitted to the GCE or higher for sign-off. These safeguards served to protect the integrity of the confinement process and provided assurance to to the ultimate approval authority that the confinement memo was properly considered before being sent to him or her for sign-off, that being the GCE.
Yes.
147, however, for reasons of confidentiality, some of the McKinsey confinements, such as manganese, NMPP, and iron ore transaction, did not follow the normal review and sign-off process. This meant that the confinements were taken to the GCE for sign-off with little or no input from reviewing bodies. You see that?
Yes.
Now, we've seen in relation to those contracts, they were compiled by Mr. Singh and you signed them.
Please go on to read 148.
I beg your pardon?
Please go on to read 148.
The 2013 PPM states that in instances where confinement is confidential, the GCE may approve such confinement without the confinement request being routed by any other authority. This was based on a provision in the 2013 DOA framework that allowed for confidential confinements.
Yes.
There are a number of concerns with the manner in which confidentiality was invoked in the McKinsey confinements. First, as already stated, multiple layers of review were bypassed as a result of invoking the confidentiality provisions.
Yes, no. My point was, so it could be done in terms of the 2013 PPM, but also if you look at the footnote on page 64, Mr. Volming says the 2013 version of the PPM applied to the McKinsey confinement.
Yes, but perhaps I could ask you if you wouldn't allow me to also go to another paragraph in the affidavit.
Yes.
So firstly, he says there is a number of concerns, and he talks about the multiple layers. I understand your answer to that. Then he says, secondly, the confinement memos contain very little, if anything, that explains why the submissions were confidential.
Yes.
Why were these contracts, why were they confidential? Because there could be a bypassing of the process potentially, but then, of course, it would need to be confidential.
Yes.
What
Chair.
was confidential about these 4 contracts?
Chair, if you go to the memo itself, in the memo,
Yeah.
it says that the
So what page are we on now?
1286,
1286, yes.
it says we are of the view that
Sorry?
1286, paragraph 27,
Yes.
we are of the view that this matter complies with grounds A and D as set out below,
Yes.
and the request for confinement is therefore fully supported.
Yes.
Now, D in page 1285 says when goods or services being procured are highly specialized and largely identical to those previously executed by that supplier, and it is not in the interest of the public or the organization to solicit other tender offers, as it would result in wasted money and or time for Transnet. When this particular ground is intended to be used as a ground for confinement, it is important to note that all prerequisites must be satisfied. That is, the goods or services must be highly specialized, almost identical. And then in paragraph 28, at the bottom, in the table,
Yeah.
Any new service provider would have to develop its own methodologies and tools, as well as obtain operational experience within a coal rail environment. Due to the specialized nature of the work, a new service provider will be required to understand the intricacies of Transnet's operations, capital program, and overall MDS.
Yes.
Yes.
So what you've explained
Those
is,
are the reasons that were advanced.
is, but those reasons, and that's Mr. Formick's point, those are reasons A and D why you go the confinement route. They don't deal at all with confidential confinements.
But it is implied in there. The specialized nature of the work, a new service provider will be required to understand the intricacies of Transnet's operations, capital program, and overall
Yes, but
MDS.
why does that make it you need for a confidential confinement?
No. The question is, did I understand that at the time?
Or did you?
Of understanding, Mr. Maybeck, please be patient with me.
Sure. Well, I'm asking you, did you understand it at the time?
No, I don't think that was necessary because I was explaining.
Sorry, what do you think was not necessary? Understanding the need for confidentiality? Or is it something else you're talking
No,
about?
Mr. Maybeck interjected as I was answering and said, did you?
Okay.
Yeah, and I felt that that was not necessary.
Mr. Malefe, if I might just say that I interjected asking exactly the same question as the chairperson. I simply didn't understand what you said. You're more than at liberty to answer the question.
My understanding is that in terms of this memo that were put forward to me,
Yes.
the reasons, the grounds for the confinement were stated,
Yes.
and the grounds for the confinement referred specifically to the procedure procurement manual, paragraph 15.1.2, and that they were elaborated on, and I saw nothing untoward at the time of signing.
Mr.
So when Mr. Volmink exposed afterwards says that it did not cover confidentiality sufficiently, well, I must say that was not the concern that I had at the time. The fact of the matter is that the grounds for confinement are in paragraphs 25 to 28, and at the time of signing this memorandum, I had no issues with the grounds that were advanced. In fact, I felt they were sufficiently articulated.
But you approved this by yourself, these 4 contracts.
Yes,
you did it yourself.
I approve everything by myself.
Yes, but the point is,
After recommendation.
oh, well, that's really what I'm getting at.
Yeah.
I mean, we've seen other examples.
No, the people that
Mr.
recommend.
Malefe, wouldn't you let me
Hey,
speak?
Mr. Mulafe, let him finish, Mr. Mayberg.
No, but Chair, when he does the same, you must also tell him to let me finish.
No, I've done so before, even yesterday. So I protect each one of you from each other.
Yes.
Mr. Malefe, we
I
just,
think it will be better if we address the Chair.
yeah, well, that's fine. You can do what you want, but the point is, do you
Mr.
accept
Mulafe,
that
you can't divert everything to me.
you'd probably be much worse off if the chair was asking the question. So let me rather ask. Can I just, in some respects, you could help us understand this. In relation to these 4 contracts, and you must tell me if my understanding is wrong from what I've seen, you approved them yourself. I mean, Mr. Singh, it wasn't a recommendation by him. He compiled it, he gave it to you, and you approved it.
Yes.
All right. We've seen one other contract, I beg your pardon, confinement, that went through multiple layers of approval, also of a confinement, correct?
Yes.
Now, as I understand what Mr. Formink is saying, is that really you don't have the power as the group chief executive to yourself approve any confinement. The only time that you might be able to get close to doing that is in the case of a confidential confinement. But even then, he explains that it needs to be reviewed by other parties. So I just want you to assist us with understanding, how did you come to, we talked about these one-man acquisition councils. How did you come, in the absence of this being confidential, to approving these contracts.
No, I don't agree with you that
Okay.
there was the absence of
All
confidentiality.
right. So then I need to, and before I move on, Mr. Fulming
Well,
said,
maybe, Mr. Mybeck, before you continue, let me just go back a little bit. I wanted to ask something about the fact that Mr. Singh presented himself in that memo as the compiler of the memo,
Yes.
whereas we have seen other memos where he was recommending.
Yes.
So the question I wanted to ask you is whether where a memo that lands on your desk for you to provide approval for something has somebody who has compiled the memo, but there is no indication that that person recommends that you should approve, whether the compiler is taken as somebody who is recommending or not necessarily. He is just a compiler, and it means that you have approved. If you do approve, you have approved without there being anybody recommending approval.
Yes. Chairperson, if we go to Mr. Volming's affidavit.
You swallowed the last word?
If we go to Mr. Volming's affidavit.
Oh, yeah. Do you have it or you are looking for it?
It's on
Do you want Mr.
exhibit Bravo 2.1A.
Did you say D or E at the end?
A for
A.
alpha.
Oh, okay. Okay, just continue.
Which page was that, Mr.?
Or the one with the compiler? The memo?
No, Mr. Volming's affidavit.
Or Mr. Volume affidavit? Mr. Mybeck, do you want to help Mr.?
yes, you find that we were at page 64 last time of exhibit
64,
BB 2.1 little a.
PSV 64.
Sorry, PSV 64. That's where we had stopped. In fact, I think we had stopped at PSV 65.
Yes, I am at 65.
65. Now, Chairperson, first look at the footnote 75. At the bottom of the page.
Footnote at 65,
64.
yes.
PSV 0060. It says the 2013 version of the PPM applied to the McKinsey confinement.
At page 64, footnote 75, you say.
Yes.
The 2013 version of the PPM applied to the McKinsey confinements.
Yeah.
Uh-huh.
And in paragraph 148, it says the 2013 PPM stated that in instances where a confinement is confidential, the GCE may approve such confinement without the confinement request being routed via any other authority.
Yes,
Yes.
Yes.
So it was possible to do what you were doing.
yes, yes.
And so the question becomes, did we consider it? Did we consider these confinements to be confidential?
Yeah.
And then I refer you to,
Okay, before you go far, I think you probably have my question in mind and Mr. Mybeck's question in mind. What you have just said, I think I understand within the context of Mr. Mybeck's question. But for me, the only question I was asking is whether compiler was taken to be also recommending or not necessarily.
well,
Whereas
this thing-
Mr. Mybeck's question related to whether you could approve something without it being recommended by somebody else.
yeah, but it says without the confinement request being routed via any other authority.
No, I understand that insofar as you mean. you did not need to have it recommended by somebody.
Yes,
I understand that part.
yes.
Is that supposed to mean compiler means just compiler and not necessarily that?
Yeah,
you
it could
also
have been a
recommend?
compiler, it could have recommended, or it could have
Yes.
compiled.
Yes, okay.
Yes, yeah,
Okay, you could approve without, so to speak, a recommendation.
yes.
Yeah, okay.
Although even a recommendation, oh yeah, okay, let's just say even
Yeah.
without the recommendation.
Okay, all right.
So now the question becomes, did these qualify from a point of confidentiality to be treated in the manner that the 2013 PPM
Prescribed.
envisaged, prescribed? And what I said is, all right, okay, fine. Now, where are those things, Mr. Mabeck? Oh, yeah. If you go to the memo, the memo on PSV 1286,
One, 286.
yes, PSV 1286. So if you look at in 1286, in that table, PSV 1286,
Is that BB 2.1.D? Not really. On the spine? Is that exhibit?
PSV 1286,
On the spine, what is written?
BB 2.1, D for Delta.
D for
Delta.
Okay. And then page 1286.
1286.
Okay, I've got it. Yes.
Now, so now we are trying to determine whether these things can be considered confidential. So the second block D, goods and services being procured is highly specialized and largely identical. Now, on the right, it deals with this specific case. The left is what the procurement manual requires. So there are bullet points there. Amongst them, the skill requires specialized management skill in managing operations within a coal rail environment. McKinsey has a proprietary coal demand and supply models as well as key operating philosophies that Transnet can use. The tool is available from only one supplier, that is McKinsey. We have satisfied ourselves that there is no new entrant who can perform the work through the following manner. These philosophies and tools have been implemented and delivered increases in volume tempo at desired levels in the past. McKinsey has provided this type of service in the past to Transnet Freight Rail. Any new service provider would have to develop its own methodologies and tools as well as obtain operational experience within a coal rail environment. Due to the specialized nature of the work, a new service provider will be required to understand the intricacies of Transnet's operations, capital programs, and overall market demand strategy. So what it is saying there is that McKinsey has done this work. They have a proprietary ownership of the models that they have used. A new entrant would either have to use McKinsey's models or develop their own. And then they would have to understand Transnet's business, operating model, capital program, and overall MTS. I think that this satisfies the confidentiality.
Well, I'm sure Mr. Mabeck is going to ask you how.
Yeah, I'm just going to ask one question, really, and that is, we've got a lot else to deal with. But Mr. Fulming deals with that, and he says, in effect, you make out a good case for why there should have been a confinement, but you make out no case for why it had to be confidential. Because it's only confidential confinements that you are allowed to, as you point out, approve without routing to any other authority. But I'm not sure there's anything else that needs to be said here. Do you want to add anything more to your answer?
Confidential, of course, means
Secret.
only a few people should know about it.
Or about the memo.
Well, I take it that if it is said that certain confinements must be confidential, the requirement of confidentiality is there to protect certain interests. That's what I'm thinking.
Yes,
Yeah.
and in this instance, it was the proprietary call demand and supply models. I agree they were not in the memo, but my understanding of confidentiality was that we are dealing with confidential Transnet information, and in this instance, the confidential information of McKinsey of the proprietary models of McKinsey. So that is where, in my understanding, confidentiality kicked in this instance. That was my understanding. It may have been flawed, but that was how I understood it at the time.
Okay. Mr. Maybe.
Yes, I just wanted perhaps to put to you, I mean, isn't a good example of a confidential confinement really where you didn't want anyone to know within your organization? You were doing something that needed to be secretive, because if people knew about it, that it would undermine that. I mean, one can think of many examples, I suppose. But isn't that really when you would invoke?
The PPM said confidentiality. It didn't say within the organization.
Sure.
Yeah.
But I'm just trying to engage you. I mean, would you agree with me? I'm trying to work out, when would you invoke a confidential confinement? Presume it's because you don't want other people to know. You don't want it to go around the organization, because that could itself then breach the confidentiality.
No, in this understanding, I'm saying my interpretation of confidentiality means the confidentiality of the tools and the information that a supplier would need to have. So it's not confidentiality within the organization, but confidentiality, as I understood it here, confidentiality in as far as if other suppliers came in.
Well, I don't think I can take it much further. Just to repeat that Mr. Formink is saying in response to what you say, is that you've made out a good case as to why there should be a confinement on grounds A and D, but not one as to why you should invoke the extraordinary confidentiality confinement provision.
He's entitled to his view.
I beg your pardon?
He's entitled to his view.
Sure. And it seems that you're at loggerheads there.
Sorry?
You have different views when it comes to that.
Yeah, it would
All
appear
right.
that we have different views.
Okay. Now, let me move on. I've then dealt really with, so far, a whole series of contracts, consultancy contracts, advisory contracts involving regiments.
I don't want to disturb you. I just mentioned this, and Mr. Mlefa, you can say something if you wish to, but you don't have to. It may well be that that requirement of confinement was put in there for Transnet's benefit.
Yes.
And not for outsiders, because it's the confinement that must be confidential. So you want
The reason for the confinement, Chair, is that where you cannot source the goods or services anywhere else, then you can confine. Let's take...
That's just the confinement.
Yeah, that's just the
I
confinement.
understand that part,
Yeah. So let's say that what we required is a Mercedes-Benz C-Class. You won't get it from BMW. Now, part of the reason you can't get it from BMW is that Mercedes-Benz has proprietary assets, proprietary knowledge of the Mercedes-Benz C-Class. And that is secret, that is confidential to them. And therefore, for reasons of confidentiality, you can't go out and say, I would like, for example, Kentucky Fried Chicken with its secret recipe from everybody.
Well, you see, I think when you talk about it in that context,
Yes,
then the requirement for confidentiality is not necessarily for the benefit of Transnet, but is for the benefit of the person who has got some proprietary rights. Whereas the proposition I was putting to you earlier was that it may well be that the requirement in Transnet's policy that there should be certain confinements that are confidential was put in there for the benefit of Transnet, not for the benefit of outsiders.
well, the PPM didn't go that far.
Yeah, okay, all right. Mr. Mybeck?
Thank you. Could I then take you back, please, to Bundle 5, Exhibit BB22, your exhibit?
So we can put away this one.
I think you can keep those, just keep them for the moment.
Bundle 5.
Did you mention the page already or not yet?
130, Chairperson, 130.
Thank you.
Yes.
Direct your attention to two other contracts that you were involved in. At paragraph 51, on 9 September 2014, deadline for submission of the SWAT 2 bid of McKinsey and Regiments. This is another contract that has been awarded for McKinsey and Regiments on a confinement basis without competitive bidding, and which is later discovered to have been used by regiments to launder Transnet payments through Homex and other Gupta laundry vehicles designated by ESSA. You recall that you were one of the signatories to the SWAT 2 confinement.
Yeah, I may have been. Do you have the agreement?
Yeah, we'll come to that now. And then the next paragraph 52, we see on the 24th of March 2015, there was an entry in Mr. Segar's diary for a meeting with Mr. Essa and Wood. Can leave that out for present purposes. On the same day, 25 March, Brian Malefe issues his recommendation for the GFB contract to be awarded to McKinsey and Regiments on a confinement basis without any competitive bidding. This is another contract which is discovered to have been used by regiments to launder Transnet payments through Gupta laundering company. See that?
Yes.
Perhaps I could just take you to those two contracts quickly. We are back in Mr. Forming's bundle. Exhibit BB 2.1, little d.
Yes.
And this confinement appears at page 1273, or one of them does. 1273. And it's signed at 1280.
Yes.
And that goes through various layers, correct?
Yes.
And then the GFB contract, I think we find at page 1314. 1315. PSV 1315. Is that right?
1315.
Yes, and it's signed, I think, through multiple layers at 1322.
Yes.
Mr. Gama, Mr. Singh, Mr. Malefe this time. You see that?
Yes.
All right, so just to summarize, Mr. Malefe, what we've been dealing with for the better part, I suppose, of a day is the 1064 transaction advisors contract that we started out with yesterday.
Yes.
We've dealt with increases in the scope of that contract, increases in payments to regiments. We've dealt with the Allied China Development Bank loan and payments to regiments. We've dealt with the 4 confinement contracts or confinements that were entered into in 4 days. And we've also dealt with these remaining 2 contracts, SWAT 2 and GBF.
Yes.
That's what we've been dealing with for the better part, really, of a day.
Yes.
And as you know, certainly according to the money flows team,
Yes.
all of the, or half of the remuneration, in effect, that was earned by regiments in respect of those contracts working alongside McKinsey and sometimes by themselves, went to Mr. Essa, and there was then money laundering in favor of the Guptas. I just wanted to put that to you so that you understand the extent of the money laundering. It ranges through all of those contracts. You appreciate that, I know by now.
Yes.
I want then to turn to the next topic, and that is the procurement.
Before we close that, if I may, Chair, I think the discussion of these contracts clearly show that the contracts were awarded in terms of Transnet policy, and that I was involved in the award of the contracts, and that there were clear recommendations for the award of the contracts, and the grounds for the award of the contracts was clearly set out in the memorandums, and that on the basis of what was presented in the memoranda for the award of the contracts, they were awarded. However, what was not shown was that I knew that part of the payments would go to Mr. Essa, or that there would be money laundering involved. That has not been shown. Or that I knew or intended that the contracts should be used for money laundering by Mr. Essa. It actually starts with the fact that I don't even know Mr. Essa. But I don't think it was shown in this exercise that I knew or intended that and so, just to close the comment, I also deny any suggestion that I knew or intended that these contracts would be used for money laundering or any other purpose other than what is contained in the memoranda that I have signed.
Thank you. So, Mr. Malefe, I want to now move from the procurement of consultants and advisors to the procurement of locomotives. And I'm going to ask you some questions, I'm sure, as you can imagine, in relation to the 95 locomotives, the 100 locomotives.
Can I just
Which bundle should we go to?
It's not one discrete bundle,
Okay.
Chairperson.
Okay.
We also want to undertake a bit of housekeeping, like I am.
You will let us know once we do need to go to any particular bundle.
I'm going to start by going to exhibit BB3, little a. That's Mr. Mohammedi's bundle.
BB 22 can go for now? I take it can go, can be taken away for now.
Yes, Chairperson.
Yes.
Now, Mr. Molefe, I'm sure you'll appreciate that I'm going to have to try and focus in relation to the locomotives onto the core issues, otherwise we could literally be here forever. So you'll bear with me. I'm not trying to trick you or not tell the whole story. I deliberately want to try and focus on what I consider to be the key issues. And in relation to the 95 locomotives, I want to start off by just dealing with one discrete issue, if I may. And if I could ask you, please, to turn to Exhibit BB3, little a, that's Mr. Mohammedi's exhibit, and ask you to turn to page MSM 203. You'll see at pages 203, 204, and 205, there are a series of emails, which I just want to ask you one or two questions about, if I may.
Yes.
We know that the RFP in relation to the 95 locomotives was issued on the 6th of December, 2011.
6th of December.
The RFP was issued
Yes.
on 6th December 2011.
Yes.
Is that correct?
Yes.
Now, if you have a look at the email at the foot of page 203, it's from Mr. Gary Peter to someone at CRS. And it says, "Dear Mr. Wang Pan, my CEO, Mr. Brian Molefe, advised me that you met in early December. He also stated that CSR showed interest in participating in our next tender for the 95 electric locomotives. I wish to advise you that this tender has been released and is available." So when in December did you meet with this gentleman?
My recollection was that it was before the 6th,
It was before?
before the tender was issued.
Oh, okay.
Yes.
Well-
What actually happened? The meeting was organized by I think it was the Chinese embassy. And they said that there is a company that manufactures locomotives in China. And they have never done any business with Transnet. And that they would like to come to South Africa to have a meeting with Transnet to understand Transnet's business. So they came, quite a big delegation actually. And they made a presentation about their company, and they manufacture locomotives and who their clients are and so on and so forth. At the beginning, of course, we made speeches about how the people of China and the people of South Africa have always worked together and are brothers and so on. So it was a very nice diplomatic meeting. And at the end of the meeting, I said, well, if you're interested, we will soon be having a tender for the acquisition of locomotives. You are more than welcome to bid. And I think that either Gary Peter was in that meeting or I must have said to him afterwards, this company, and maybe I didn't even give him their profile, is interested in bidding for the 95 locomotives. Please contact them because they did say that they're interested.
So do I understand that at the time that you met with CSR, you knew that you were on the point of issuing an RFP?
Yes. Yes, I mean, that was in the MDS.
So it must have been a few days before on your version.
I think it was a few days before because Gary Peter says here in early December.
Yes.
So it was maybe a few days before, but it was definitely before because I remember saying to them, we will be going out to market very soon. And if you really are keen on starting to do business with us, maybe you should start by submitting a tender.
And then if you go towards the top of the page, there seems to be...
And Chairperson, encouraging people to submit a tender is not a bad thing because it improves the competitive tension in the tendering process.
What we see at the top of the page then seems to be a response from CSR on the 19th of December.
Yes.
Thank you for your email. We were very pleased to have a chance to meet with your group CEO, Mr. Brian Molefe, at the beginning of December.
Yes.
We expressed our interest in your tender for 95 electric locomotives and the South African market as well. And then it ends off, you are very kind to facilitate us your support on the tender document if we need and inform you. Do you confirm
Yes.
that?
Yes. I think that, like I said the other day about Mr. Koko, and this sentence may be a reflection of how they would have put it in Chinese, but now they were writing in English. To say that, yeah, I don't know, we are interested in this.
All right.
Any assistance will be welcome, something like that, but it's not elegant.
And then can I
It's a
take you
reflection of, it's something that is done by people who are second or third or fourth language English speakers like myself.
Could I ask you then to please to go to page MSM 205?
Yes.
Now, it seems that what happens there is that the email at the foot of the page comes from CSR. Dear Mr. Molefe, please be kind to check attached letter, which has already been sent to you, sent by fax to you. You see that?
Come again?
You see the email that I'm referring you to?
Yes, yes.
On the 19th. And do I understand at the top of the page, is that your response?
Yes.
Thank you for your letter. I'll forward it to Mr. Gama, who will process and respond to your request. Thank you for the interest shown in the tender.
Yes.
And can you recall what that letter said or provided for?
I think that letter was may have been a request to visit our facilities, our TFR facilities. And all I did was to send it to Mr. Gama, firstly because he's the group executive for TFR. And secondly, if these people were bidding, the bids were being evaluated from TFR. And so they would deal with the fact that if this guy is a bidder and is making contact, what are the implications? So I did not do anything with this letter other than to forward it to TFR for them to deal with as they see appropriate. And what I did was to inform them that that is what I did.
All right, I'd like now to move to the 100 21E electric locomotives. All right?
121.
121E electric locomotives, perhaps just ease of reference, 100 locomotives.
Oh, okay.
Chairperson.
I don't
Okay.
know you to move so
And the
quickly.
page where we are going would be,
I think we're going to start getting into Mr. Callard's exhibits now.
Mr. Callard's one is a different bundle.
It is, yes.
So we're done with this one.
Yeah, it's a different bundle.
Mr. Callard is BB4 little a. All right. Again, I'm going to summarize some of the evidence so that we can try and get to the point. You will remember that in relation to these locomotives, there was an approved business case for confinement to Mars, which is also referred to as Mitsui on occasion.
There was an approved business case for confinement to Mars.
Yeah.
Mars, Mars is a Mitsui.
Yes, okay. I mean,
Yes.
should I call it Mars or Missouri, which would be the better term?
Either one, as long as we understand that we're talking
Yeah.
about Mitsui.
Okay, let's use Mitsui then. But we know that ultimately, and we're going to come to the detail, we know that you withdrew this and you recommended instead confinement to CSR, correct?
Yes,
In a memorandum to the board dated the 21st of January 2014.
yes,
And I take it you will accept that several grounds for confinement in the Mitsui memo were then reproduced in the CSR memo.
yes,
Now, do you accept also that Mr. Callard was the author of the Mitsui business case?
Yeah, you see, Mr. Khaled was the author of the business case for the confinement of 100 locomotives.
Yeah. All right. Well, I think we agree with one another. Now, I want to go to the 23rd of January 2014, when Mr. Callard complained to Mr. Garma. And I see,
Yes.
I see you have some documents there. Do you want to refer to them or what?
Yes. Mr. Khaled,
Do you want to refer to those documents now, or do you want to do so later? Or
well, before you even ask your question, Mr. Khaled says that he did not know about the confinement to CSR. And I have, firstly, and the reasons for the confinement to CSR. Firstly, I have documents here, Chairperson, that I got also in the course of the last 1 or 2 days.
Don't speak away from the mic.
I say, firstly, I have a few documents here that I got in the course of the last 1 or
Last
2
night.
days.
In the course of,
In the course of the last 1 or 2 days.
oh, okay.
Yeah, I've got some more documents.
Wait.
And these are documents, these are, and these I had not seen before. But somebody who is at Transnet came to me
Okay,
and said that I am aware that
they are relevant.
Mr. Khaled is saying that he did not know about the confinement for the 100 and the reasons for not confining to Mitsui. But these are reports from engineers that detailed the failures of the Mitsui locomotives over a period of time. In fact, what this guy was telling me was that the train drivers and the engineers on the coal line were relieved that we eventually did not confine to Mitsui. And these are letters and emails to Mars, to the Mr. Ravine, Acting Chief Executive of Transnet Freight Rail,
I guess that what we should do is, have you got copies for the legal team or not really? Do you have?
Chairperson,
Did you get a chance to have copies made for the legal team of the
I
commission?
don't have copies,
Okay, but you
but
can.
I don't mind parting with these copies.
Well, maybe you can make them available to,
Because after today, if somebody says Transnet to me,
to the legal team, and they will in due course have a look at them and see what should be made of them.
but what is
But
detailed in there is that the
If you need to refer to them in your evidence, I'm sure that can be dealt with.
All right, I'd like to take you, please, to page FQC 216. Right, so on the 23rd of January, Mr. Callard writes to Mr. Garma,
yes,
and it seems also to, is it Mr. Gianni, would it be?
come again.
Who's Tammy?
Mr.
That's Gianni.
He writes to Mr. Gianni as well.
Sorry?
Did you say he writes to Mr.
Well,
Gianni?
I'm asking you, it says Dear Sia and Tammy, is that Mr. Gianni?
That's Mr. Gianni.
All right. He says, this is a difficult mail to write. In helping to format a recent version of the 180 locomotive business case on Wednesday 22, that was the day before, I noticed that the case was changed from that which I had submitted on Monday. This email is because of the nature of those changes and the implications. The implications are technical and in the rationale for the acquisition, which was speedy delivery to mitigate MDS volumes at risk. Project Shongololo was predicated on 19 equivalent locomotives. These locomotives are 26 ton per axle. And then he says, in the next paragraph, the locomotives proposed, this is in your business case, are not explicitly specified, but if a current and delivered design is the criteria, then it is the E20. This locomotive is a 22-ton axle locomotive. Goes on to say, this was specified as a GF locomotive. The implications are that the locomotive is not a heavy haul locomotive, is not as powerful, and the locomotive calculations for Operation Shongololo no longer hold, and the project and volume targets may be at risk. Furthermore, the locomotives cannot interoperate with the current 19E locomotives, adding further complexity. To have the 20E interoperate with the E19 will require that they be fitted with wired DP at an additional cost of around R1 million per locomotive. If the locomotives are of a new COCO design, which will meet the power requirements, then all the arguments relating to time saving, using proven design and eliminating type testing no longer hold. Then over the page at FQC 217, the TE assembly line for the current 20E has yet to produce a locomotive. If local assembly is the criteria, then ramping up this line up to meet the 95 20E and this 100 delivery criteria is a risk that has not, in my humble opinion, been visibly addressed. If imported as complete units, then the local content is problematic, though the delivery program is achieved. Respectfully, for your information and consideration. Now, did you ever see this email from Mr. Kellard?
No, I just saw it recently.
All right. So I would want to then take you, if I may, to page FQC 219. Mr. Garma, Mr. Kellard sent the email to Mr. Garma on the 23rd of January at 15:50. That evening at 21:22, Mr. Garma wrote to Mr. Singh.
Yes.
Says, "Hi, Mr. Singh. I'm afraid the submission of the 100 locomotives is a mess and will need to be withdrawn.
Yes.
The 20E locomotive is a 22-ton, this really mirrors what Mr. Kellard had said. The 20E locomotive is a 22-ton per axle locomotive suitable for GFB, while the 19E locomotive is a 26-ton per axle beast suitable for the coal line. The two locomotives types are not interoperable. While CSR can make additional locomotives in China in a very short space of time to mitigate against MDS volume loss, this would be counter to our localization strategy and would have to be spelt out. The 85 locomotives to be assembled by TE has not yet commenced. We cannot yet make any argument that this would reduce the risk. Any argument, therefore, on the 20E ought to have been a GFB argument, which then means we accelerate GFB, but we need to go out to tender for 19E type locomotives. The 20E loco is not heavy haul locomotive, but is a less powerful loco than the 19E. So, would you accept that what Mr. Garma really does is he forwards to Mr. Singh the same concern raised by and large, Mr. Kellard?
The same misinformed concern.
Sorry?
I say the same misinformed concern.
Yes.
Because their understanding was that the confinement to CSR was for a GFB locomotive and not a heavy haul locomotive. And in fact, Mr. Kellard may have implied that CSR does not have the capacity to manufacture a heavy haul locomotive. But CSR did have that capacity to manufacture a heavy haul locomotive. In fact, the heavy haul locomotives that they manufactured were much, much more powerful for our requirements that were in operation in China. And also the speed with which they could manufacture the locomotives. I mean, their production line is very impressive in how they can churn locomotives out of their production line. So I think that to the extent that Mr. Kellard and subsequently Mr. Gama think that CSR was incapable of manufacturing a heavy haul locomotive, correct. But I think that you may have to speak to Mr. Gama himself and to Mr. Gianni.
Now, we certainly are going to speak.
Incidentally, I met Mr. Gianni socially somewhere, and he said to me that the commission is refusing that he come and gives evidence.
Refusing.
Yes, that's were his words.
All right.
He says they don't want me there. He says it's requested and requested and requested, and they don't want me to come and give evidence.
And did he indicate to you that he's happy to give evidence?
He said the commission, I don't know who it's in particular.
Well, it would be important to see if he has got any correspondence to that effect, or if he can give people's names. But what I can say is that for some time, knowing that our lifespan is limited, we have been seeking to make sure that we are careful in terms of the importance of evidence that witnesses will give, who come will give. But if there is any correspondence, I'm not aware that necessarily anybody has made any decision on that. But it may well be that what he's talking about is that he may have been in communication with either some members of the legal team or members of the investigation team, and they have not said they would.
No, he showed me correspondence from before he left Transnet, from an acting group chief executive, not the current one, but the guy who was acting before. I can't remember his name. His name, which specifically forbade him to come to the commission.
Somebody from Transnet.
From Transnet, but also on his own volition, he made contact with the commission.
Yeah.
And was given a cold shoulder.
Yeah.
And Mr. Gianni's chair was at the center of this Locomotive's acquisition. It was quite central. He is the person that the newspapers, or Mr. Popo Molefe, in his evidence here, said that he replaced somebody with a 17 years experience with a teacher. Mr. Gianni is that guy who's called a teacher. He started off as a teacher, but ended up with 2 degrees in business. So it was not correct for Mr. Popo Molefe to say that a teacher replaced the chief executive of Transnet Rail Engineering. And that was Mr. Gianni. I think he's key and should be listened to by the commission if you really want to know what happened to the Locomotive's acquisitions.
Well, all I can say is that if he has been in communication with the commission and he believes he has information that would be helpful to the commission and has supplied the information, or has not supplied but would like to supply, he should write to the secretary, or if he wishes to take advantage of the fact that you met each other recently, he gives it to you to give to your lawyers to send to Mr. Maybeck, whatever information he may do so. All what I can say is there will be people who would have wished to come and testify that will not get a chance to, simply because of the reality of time. Some of the people, if they had approached us much earlier, they may have been accommodated, but others might not, because they may be approaching us late. But certainly what we would want to do is look at the information that anybody brings and assess its importance. As we speak, we are 2.5 weeks away from when we are supposed to end with oral evidence. So that and there are a lot of people
Mr.
that we
Gianni
are
is
trying
very
to
critical.
accommodate.
I'll give him your cell phone number, Chair, because the secretary is not very helpful because he has issues. I think it has to do with the fact that he once lost a tender and lost a court case.
Well, can we say,
past.
speak to Mr. Gianni, if he doesn't mind, then maybe if he can channel whatever documents through your lawyers to Mr. Maybeck, and then we can take it from there.
To Mr. Yes.
Yeah.
Certainly.
Chairperson,
Yes.
we really thank you for the offer, and we'll make use of this offer.
Yes.
We will contact Mr. Gianni, compile all the information related to
Yes.
Mr. Mayberg,
Yes.
and
Okay.
copy the Secretariat of the Commission.
Yes. Okay. No,
Thank you very much.
Okay.
Thank you, Mr. Malefe. So just that I understand it, when you say that Mr. Gama, because we know we're going to have Mr. Gama here and we will in time deal with these locomotives with him, but just that I understand it, you say he also got the wrong end of the stick.
I think from reading
Yes.
this,
And just so that I understand it, at this point in time, was presumably Mr. Gama was the CEO of Transnet Freight Rail.
yes,
He was presumably a rail expert.
Mr. Gama.
Yes.
No, the engineers are the experts.
Well-
Mr. Gama was like me. He was a chief executive. He was just an overhead expenditure like me.
Well, we
But
certainly
the guys
know,
that were doing the work, the experts are the train drivers and the engineers.
so really Mr. Callard was an expert.
No, Mr. Khaled was not an expert. The
All right.
experts are the people that wrote those letters that say that the Mitsui locomotives were failing on the coal line.
So
Mr.
can
Khaled, Chairperson, is also conflicted because he works for MNS. Is it Funduzi or MNS? He was hired by MNS as part of their forensic investigation. And I think in the process of this commission, he was at pains to explain or to show how useful he could be to the MNS people. But he was a hired hand. He's a mercenary.
So, Mr. Malefe, what I just wanted to do is carry on with this email stream or string. If you go to page FQC 222.
Maybe Mr. Maybeck, we could take a break. Now I see we are at 4 o'clock. Maybe we could take a break. Are we still on the understanding that we'll continue and see how it goes? What's your assessment of how much
I still
is
have
left?
I have quite a lot still to get through, Chair,
Yes.
but I'm going to try my best to focus on what I consider to be the key issues.
No, that's fine. Do you have an assessment of how long that might be without saying that I will hold you to that?
Well, I would think probably past 7 o'clock,
Yes.
6, 7,
Okay, all
I
right.
don't know.
I must just say that for some reason, something tells me that I may have arranged for some evening session this evening, but hopefully I didn't. If I did, we'll see when the people
Well,
come.
perhaps you will tell us that when
Yeah,
we
when-
reconvene, and then we can tailor things accordingly. I mean,
Yes.
we would like to finish today, but
it-
if we can't, I suppose it's not the end of the world.
Yeah, no, it may be that there isn't. I don't know why I was feeling like we might have that problem. So we will take the break now and then we'll continue and see how it goes. Okay, all right. Let's take a 10 minutes break. I'm saying 10 minutes. We are at 8 minutes past 4. Let's return at 4:15. We adjourn.
And you see there, it appears that Mr. Singh then says to Mr. Gama on the 24th of January, quite early in the morning at 7:02, let's discuss this morning.
Yes.
Now we know that you then there's a memorandum that you sign that's presented at a BADC meeting. That's on the 24th of January, correct? The same day.
On the
24 January. Could I ask you please to go to page FQC 244.
yes.
And this is quite a lengthy document. It ends at page 267.
Yes.
And you see that that was not signed by Mr. Gama. Can you explain why not?
I can't remember why Mr. Gama did not sign.
All right. Then let's go to the BADC meeting on the 24th of January where this memorandum served. Those minutes you find at FQC 228.
FQC 228.
Yes.
Yes.
The attendance reflects you and Mr. Singh as being present and partial attendance only by Mr. Gama, correct?
Yes.
Now, at this meeting on the 24th of January, were the concerns of Mr. Callard and Mr. Gama raised and discussed?
I can't remember that they were. But like I say, are raised by who?
I beg your pardon?
You say, were they raised by who?
Well, did you raise them?
No, those emails were not to me.
Yes, but I mean, the point is the concerns raised by Mr. Callard and Gama, were they discussed at this meeting, yes or no?
No. I can't remember that they were.
All right, thank you. Now, let us go to the affidavit of Mr. Callard, and could I ask you please to turn to paragraph 49 at page FQC 12.
FQC 12.
FQC 12, yes. So, Mr. Callard at paragraph 50 at FQC 12 says the minutes do not reflect that the BADC was informed of my concerns raised in the email correspondence. Then over the page at FQC 13, the minutes reflect that the BADC, according to Mr. Callard, was misled by management as to the validity of the confinement process by one, creating the impression that the 26-ton heavy haul CSR locomotive existed, when in fact this is not the case. Using Chinese manufacturing facilities to motivate for speedy delivery, which would have negated local content requirements. See Mr. Gama's mail in this regard. And 3, reporting that the confinement was in compliance with the PPM when no previous product existed. Do you want to comment on that?
Yes. The Chinese had a heavy haul locomotive. that in fact was even above the standards that were required. So that is not correct. And I even have a model of that locomotive. So that locomotive did exist.
All right. Any other comment?
The Chinese manufacturing facilities would be used because manufacturing these locomotives in China would give us the 100 locomotives very quickly. On the coal line, which was in dire straits because the coal producers. So this takes us back to that, what I had said in the ESCOM stream, because the coal producers had been complaining that their coal is not being taken to Richards Bay. And so we said we can get the locomotives very quickly, but you have to sign take-or-pay agreements. And then there was the incident with Glencore. And secondly, the GFB, because we would take 100 locomotives from the GFB, from the coal line to GFB, to revive the GFB business. So the GFB business required the locomotives. And as far as I'm concerned, the confinement was in compliance with the procurement procedure manual.
All right. Then you see at 53 that 100 locomotives were confined
Yes.
to CSR, and then on the 4th of February, Mr. Callard receives an SMS from Mr. Garma in response to his email of the 23rd of January stating, "I've just seen your email. I would explain to you the GCE's thinking." He says that wasn't followed up. Of course, he had seen it before because he addressed Mr. Singh in relation to it. But I've just seen your mail. I would explain to you the GCE's thinking. Have you any idea what that
I don't know,
entails?
maybe, I don't know. I don't know what it is that he was going to explain to him, but I suspect it may be what I've just told you now.
Why did you not just stick with Mitsui?
Because they were failing, number one. Number two, there had apparently been several confinements to them. There had been confinements to them in the past, and a view had been expressed that we should try not to have existing suppliers that have been supplying locomotives. So they had won the tender quite a few years back, and there had been a few confinements in between. And so there was a concern that we would be entrenching monopolies, yes, those are the words, entrenching monopolies by using suppliers that won a tender a few years ago, and then we just, like mandate creep or scope creep. Every time we need locomotives, we just confine to them.
So just as I understand it, though, you were in favor yourself of confinement to Mitsui,
Yes,
and you motivated it on a series of grounds saying it must go to Mitsui.
yes,
Subsequently, you were in favor of confinement to CSR,
yes.
and you motivated on the same grounds.
On the same grounds.
Right.
Because what we needed was 100 locomotives.
And the only thing that caused that, as I understand it, is you say a concern was raised about entrenching monopolies.
Entrenching monopolies.
And who raised that concern?
I can't remember, but it was in the context of the BADC.
But had it not been for that, the tender would have been awarded, obviously, to Mitsui.
Might have been awarded.
Yes.
But subsequent to that, and this I had forgotten, there had been complaints that the Mitsui locomotives had been failing. And I had actually forgotten that until I was reminded.
Now, let's deal with another issue.
Just remember not to be too far from the mic.
Okay.
Yeah.
I want to turn then to another topic relating to the 100 locomotives, and that is the increase in the ETC from 3.8 billion to 4.8 billion.
From?
3.8 to 4.8. So the evidence seems to be that
Okay,
the tender was awarded to CSR on the 17th of March 2014. Would you confirm that?
yes,
And what Mr. Leher said, and he was part of the negotiations, he said that during the negotiations, an offer was made by Transnet of 38.5 million per loco. The counter offer from the suppliers was 49 million, and you agreed then to 44 million. Does that roughly accord with what you remember?
what I remember is that the base price of the locomotive was 28 million per locomotive. That was the base price of the locomotive.
Yes.
Now, the thing about locomotives, depending on where you buy them, is that there are other costs. And the other costs include the lifetime cost of the locomotive, which is the cost of maintenance and maintaining it over the lifetime, but also the cost of financing, as well as the costs of hedging the purchase price of the locomotives. So in this instance, and in the other instances as well, our preference was to get a fixed price. Fixed price means irrespective of what happens to the exchange rate, to interest rates, and to inflation, this is the price that we will pay. So we're not entering into a contract where after a few years or even a few months, the supplier will turn around and say, no, that was the price 3 months ago. Since then, the price of steel has gone up, interest rates, differential between the countries, our countries has widened, and that the exchange rate, as you can see, has moved. So we prefer the fixed price. Now, when you go for fixed price, typically the suppliers would make you pay for it. And this differed and was a subject of negotiation. So the important thing is to know that the base price was 28 million, and then the other frills put it up. And those other frills would differ depending on where you're buying. So buying from China and buying from Japan and buying from America is not, the frills are not the same.
Now,
But what was comparable is the base price.
Mr. Malefe, what happened then, according to Mr. Leher?
According to Mr.
Mr.
Laher,
Is that Mr. Singh requested him to prepare a memorandum explaining why the price had increased from the business case submission, effectively to justify what had been agreed. And then he went on to say that on the 23rd of May 2014, you approved a memorandum to the Board of Directors for an increase in the ETC from 3.8 to 4.8. And let me take you to this document that Mr. Leher prepared together on the instruction of Mr. Singh. That you find in Exhibit BB4, little f, and then 2. So it's quite a complicated. BB4, you will find in Exhibit BB4, little f. And then it's second statement. All right, so it's BB4F, and then there are more than one statement in that bundle. It's the second statement. So that's why it's BB4F F4 in brackets F2.
Yes.
And I'd like to go to page 46. In fact, the memo starts at 47. YL RESP 47. So hopefully we all have the same thing. Mr. Malefe, do you have there a memorandum at 47 to the
Yes.
Transnet board from yourself?
Yes.
And if we go to page YLRESP 60, there you find the signature page.
Yes.
And that reflects that you was recommended by you on
Yes.
the 23rd of May 2014, correct?
Yes, by Mr. Gama and Mr. Singh.
Yeah, by Mr. Correct, Mr. Singh. So it's 3 levels of recommendation, Mr. Singh, Mr. Gama, and yourself.
I'm sorry, I thought you said page 60.
60.
Mr. Mybeck?
It starts at page 47, and the document, the memorandum is signed, the chairperson, at page 60. YLRESP 060.
Maybe this is a wrong file. I think, is that the memo that on page 60 has the headings methodology of scoring and meetings held? On page 60, is that the one?
Well, the memorandum that we're looking at starts at page 47, chairperson.
No, I think, I don't think that, let's get, what's the bundle? Is it exhibit BB4 small f?
BB4 small f, yes.
Okay, and what is the page?
it has
If you
to-
just tell me the page, not the exhibit number, just the page.
The page is 47, but there's 2 dividers. There's a first statement and a second statement. One needs to get to the second statement, because it doesn't seem to be consecutively numbered.
Oh, is that so? I think that is what may be.
Yeah,
So so it's not sequential,
not throughout the file,
or
no.
not throughout the file. Okay, so I must go to behind, after the second divider.
That's correct, chairperson.
Well, the dividers are numbered. There is 1, 2, 3, 4, 5. So is it the second one?
I'm afraid mine are numbered differently, so perhaps I could ask my,
Okay, let me see where, yes, this is
What
the
divider
reason
do you
why
have,
I
Mr.
have been insisting
Divider number is
that
25.
the,
25.
Mr. Malefe has divider number 25. Do you have a 25, chairperson?
the bundle or the divider,
Divider number 25.
let me see.
Well, it's exhibit 25.
Because that's why I insist that the pagination should be sequential from first page of a bundle up to the end, so that when anybody says page so and so, then we all know there will only be one
Yes.
such page.
You'll remember, chairperson, it seems that this was in the very early days of the commission.
Okay, now I think there's a memo here at page 47. This is page YL RESP 047.
That's
Is that
correct.
the one?
Yes, thank you.
Okay, all right.
All right. So this is the memorandum that we've been speaking of, and what I've done is I've taken you to the signature page, just so that the DCJ chairperson can see now that we all have the document.
Yes.
At YLRSP 060,
Yes.
there is
Yes,
the
I've got it now.
There is the recommendation by the three of you, Mr. Singh, Mr. Garma, and yourself. And the recommendation 89, little b at the end, is the BOD approves an increase in the estimated total cost for the acquisition of the 100 equivalent class 19E dual voltage electric locomotives for the export coal line from 3.87 billion to 4.840 billion. You confirm that?
Yes.
Now, evidence has been given by Mr. Callard to the effect that this increase of R1 billion was excessive and unjustifiable. You know of that evidence?
Yes, I may have seen it in the papers, yes.
And also, perhaps more importantly, there was the evidence of an expert in the form of Mr. Chowby, who also testified that the increase was excessive and unjustifiable. Have you seen that evidence?
Both from MNS.
So what Mr. Chowby said, and we can go to his report, is that an increase to 4.1 billion from 3.8 was reasonable, but he considered the additional 800 million to be not justifiable. Have you seen that evidence?
No.
Well, let me take you to that. You were, I think, previously given this, but where you will find it, just give me a second. In Exhibit BB 8, little b.
Come again, which?
Okay, so it's BB8, little b, and that's divided into point 1 and point 2. So there are two reports by Mr. Chowby contained in BB8B.
So which page number?
So, Chairperson, do you have Exhibit BB8, little b? And then you have a point 1 and a point 2.
I've got BB8, B.1 and B.2.
That's right. If I could take you, please, if you could please go to B.2. It's the second report in that file, right towards the end.
What's the page number?
And it starts at the first page of Mr. Chowby's report is page, and these are only red numbers, AOC 100-001. It's actually the first page, not... Mr. Malefi, you have the report? It starts at page 1. Are you there?
Yes. Yes, I've got it.
You have previously been provided with this. I mean, you've seen this before.
I can't say that I have, but fine.
All right. It was actually, in fact, attached to your... It's one of the annexes to the request for you to file an affidavit.
Yes.
But let's not worry about that for the moment.
Well,
Are
that's
you at
fine.
page 1?
Yeah, yes.
Okay. Could I ask you to turn to page 20? Under the heading Conclusion, at 5.33, in concluding, having built up the price of the E20 dual voltage electric locomotives provided by CSR as at April 2012 to March 2014, allowed for design modification costs as at March 2014 to meet Transnet's 19E dual voltage electric locomotive requirements and mitigated for risks such as foreign currency and inflation. A reasonable stroke acceptable price ETC for the transaction would have been 4.1 billion. The excess of 739 million could not be justified on the basis as explained above. Have you got any comment on that?
He's talking rubbish.
Okay. Well, let us then, and why do you say that, by the way?
Yeah.
Yes, let me come to why I say that. Chairperson, if you look at the memorandum in RESP 049, paragraph 22, it says A, Forex movements from the approved business case to the award date, so the reasons for the increase in ETC. Inflationary related escalations, variations to design for a higher specification, the cost of fixing future escalations over the life of the contract. So this is from the time that the contract is entered into for the life of the contract. And it says forward-looking risk mitigation. And then it says cost of fixing Forex exposure, forward-looking risk mitigation. And it says contingencies related to variation orders, As part of the negotiation process, a further discount of 2.4 million per locomotive was negotiated. Now, my point is, in arriving at the figure based on what is in the memorandum, assumptions would have to be made. So when you say that forward-looking, you have to make assumptions. From one economist to the other, the assumptions won't be the same. Even if the assumptions are the same, they won't arrive at the same figure. That's just how it is. That is how. So the risk mitigation and calculations for risk like this, forward-looking, is not a science. It's an art. So you can't calculate it to the cent because it's about assumptions. So what he did is that he came up with his own assumptions and arrived at another number. The people that were doing this memo and that were doing this calculation here had other assumptions, perhaps even the same assumptions, but different parameters and variables in their assumptions. And by definition, they came to a different number. That cannot be imputed to mean impropriety. It's just that if you take two risk specialists and you put them in one room or in two separate rooms and give them the same facts and ask them to calculate a forward-looking price, they will come at different numbers. They will arrive at different numbers. And part of what influences them are subjective factors. Subjective factors. I mean, it comes at the point to where even what they had for breakfast influences what their feeling is about a particular issue on that particular day. So this is not a science. I noticed yesterday when you were explaining the meaning of ETC, the E in ETC is estimated. And the thing about estimated is that if I asked everybody in this room to estimate anything, we want to have the same number. So it's not a science, it's an art. Estimation is an art. So this is the work of two artists.
Of course, even if you're talking simply about estimating anything,
Yes.
there will be parameters to say, if somebody says, what do you estimate what the price will be of that bottle in front of you? If somebody suddenly says a particular figure, everyone will say, no, that's just out. So, but if there would be certain amounts, if people give different amounts within a certain range, it's taken that that's reasonable. You accept that part.
No, Chair. We were in class when the lecturer demonstrated this. And he took a wine glass.
Yeah.
And he filled it with Tic Tacs, small sweets. And we were about 15 in class. And he says, please walk around this wine glass and estimate the number of sweets. And write down your estimate. From 15 people, the range valued from about 75 to 400. And he says, that's your lecture for the day on estimation.
Yeah, but maybe we shouldn't spend too much time on this. I mean,
it doesn't mean anything, because what you don't know is what is inside the wine glass.
Yes, no, what I'm saying is it might differ in terms of what you are talking about, but if somebody is going to come and say they estimate that bottle in front of you to cost 20,000 rand, you know, many people are going to say, no, that's complete out, just empty bottle. You know. So it might depend on a number of things, but if they say maybe 50 rand, 20 rand, you say maybe that's within a certain range, 5 rand, 10 rand, but there comes a time when you say, but that's too out.
Yes.
Yeah.
Yes.
Mr. Maybeck?
Yes, I just really wanted to make the point that Mr. Chaubi is an expert.
Mr. Chabi is an expert.
Yes. He gave expert evidence. And you've seen his report before.
Is he expert to you? I mean, I don't consider his work to be the work of an expert.
But you were given this report before,
Yes.
correct? You
Yes.
didn't go to your own expert to get a contrary view. You just want us to accept that, look, this is an art, not a science. I mean, that's essentially what you want the chairperson to do.
That
As
is
I
what
understand.
that is what I'm saying. I'm
All right.
saying that the estimation is an art, not a science. So Mr. Chabi cannot come here with definite numbers when all he did was estimate.
All right. Have You got anything else to say about Mr. Chaubi's expert opinion?
No.
I just want to take you to something in your exam.
Remember to speak
Bundle
not too
5?
far from the mic.
I beg your pardon, Chairperson.
yeah.
Bundle 5,
Yes.
Exhibit B22. I just want to take you, please, to the Regulation 10.6 notice, which you find at page 12, or sorry, page 14, black numbers.
Bundle 5, yes?
Bundle 5, Exhibit 22.
Yes.
Page, and now we're referring to the black numbers on the left-hand side. Page 14.
1-4.
Yes?
Yes.
There, perhaps I could ask you to turn to page 17, and I'd like to refer to paragraph 1.6. And just to confirm that you were asked about the opinion of Alistair Chaubi, this is at page 17, that the increase in the ETC of the 100 locomotives from 3.8, I'll paraphrase, to 4.8 was unjustifiable. Your attention being drawn to his statement dated the 26th of November 2019, Exhibit BB 8B2. You were given this report.
Yes, yes.
Right. And whilst we're on that, there's something I've wanted to ask you some time ago. If you have a look at paragraph 1.9 on the opposite page, page 18, you see there you were asked a series of questions about McKinsey and regiments.
Yes.
Sub 1, the confinement and appointment of the consortium, including McKinsey, Letsema, etc.
Yes.
Then the decision to replace Letsema
Yes.
and Nedbank with regiments.
Yes.
The session and the payment of the 78 million, things we've gone through already. The confinement and the appointment at paragraph 194 of McKinsey on those 4 contracts that you were involved in, and also the confinement and award of the GFB breakthrough. Those are things which we've already dealt with in a lot of detail. But what I wanted to ask you, Mr. Molefe, is where do we find in your affidavit your response to all of these issues, dealing with the McKinsey and regiment contracts? Your affidavit, we know, starts at page 28. Of Bundle 5, Exhibit BB 22. There is your affidavit. Perhaps you could just page through it.
Yes.
I'm sorry. Bundle 5, you said?
Yes.
Yes. Okay, no, I didn't realize it's right in front of me.
It's been a long day,
It's been a long day. Did you say 22?
To 28 is Mr. Molefe's affidavit.
Okay.
So unless I have it wrong, and you can correct me, you don't deal with McKinsey or regiments at all, or do you?
No, I don't.
You don't.
No, I don't. I think that it was in error, Chairperson.
Yet,
Please remember that this was the 12th day of November 2020. And this notice required us or me to deal with this, with all of these issues within 7 weeks. And then on the same day, there was another directive that said that, which was an ESCOM directive, which required me to deal with quite substantial issues within 30 days. And on top of that, Chairperson, I'm actually a student. It was in the middle of my exams. So I put away all of these directives and finished my exams first. And then I was under pressure to finish the 30-day directive. I even think I asked for an extension. And while I was still busy dealing with them, there was a subpoena to appear on the 15th of January. And the subpoena came with its own issues. The 15th of January was about the same time as this affidavit was due. So there was a lot of pressure. And what I did is I dealt with it to the best of my ability. And I must apologize if in the process I may have neglected to deal with the McKinsey issues. However, having said that, I would hope that my dealing with the issues today was
Was adequate.
did them justice. Yes, I hope that we dealt with them adequately, and that there is nothing that I have said today that I would not have said had I had sufficient time and to prepare and finalize my affidavit properly.
Mr. Molefe, just so I understand it, in your affidavit, nowhere do you say that there's certain topics that I haven't dealt with or I haven't had enough time.
Chairperson, maybe I can be helpful in this regard.
Yes.
The regulation 10.6 notice that was brought to our attention, which was signed by the chairperson dated the 12th of November 2020, has specific areas which required Mr. Molefe to prepare his affidavit on. And this regulation 10.6 notice makes no reference to McKinsey.
Well, you might not be having the right one. The one that Mr. Maybeck referred to does have a reference. You might be looking at a wrong one. I think Mr. Molefe had it, I had it. And
Yes, I think
Maybeck had it.
we're my learned friend, perhaps.
Yes.
We might not be on the same page, literally.
Yes.
Mr. Molefe was issued with two
Yeah.
10.6 directives.
Yes.
I'm
That's
referring
apart
to-
from the ESCOM one, I think he
Yes.
also said he got.
I'm
an
referring
ESCOM
to
one,
the
yeah.
second
The Transnet
one.
ones,
Oh.
yeah. So
Mr. Molefe-
you might be having one of them, but not the one he was referring to.
Okay, thanks.
All right, well, let's leave it at that. So just so that I understand it, Mr. Molefe, before we move on, did you then forget to deal with McKinsey regiments, or did you deliberately not deal with it because you didn't have enough time?
I think I did not deal with it because I didn't have time.
Yet you
But-
didn't mention
but-
that in the affidavit.
But as you may have noticed from the way that I have dealt with it today, had I had time to deal with it, I would have dealt with it exactly as I dealt with it today.
All right. Could I then please take you to Exhibit 27, that's bundle 6.
Are we going to go back to PSV anytime soon, or can I?
No, I don't think we are, Chairperson.
Yes, so they can take it away.
Could I take you, please, to page 117 of that exhibit, exhibit 27 in bundle 6. This is the Fundutsi report.
Just for the record, that's Transnet Bundle 6. And it's at page 177.
117.
117. Thank you.
Are you there, Mr. Malefe?
Yes.
I'd just like to draw your attention to some paragraphs in this report. Let's start on page 117 with paragraph 5.6.4.8. Are you there? In about the middle of the page. Mr. Malefe?
Yes.
It says that from Mitsui's July 2013 proposal, we determined that their ETC for 119 e-locomotives was 3.188 billion. The said ETC included all costs. Mitsui indicated that there were not going to be any escalation costs except for material steel portion. You see that?
Yes.
Do you have any comment on that?
No, I have no comment.
And then,
I have no comment other than to say that price was not the reason why we didn't go for Mitsui, as I said.
and then at paragraph 5.6.4.11, at the top of page 118, they say, based on our calculations, we determined that the total ETC of 3.8 billion was based on 112 locomotives at an estimated cost of 34.34 million per locomotive. As discussed below, the next subparagraph, we noted that the number of locomotives was reduced to 100 without reducing the ETC of 3.8 billion, which should have been reduced to 3.4 billion. Do you have any comment on that?
No, I have no comment.
You go over the page, please, to 119. At paragraph 5.6.4.18, based on documentation, CAPIC should have reduced the ETC from 3.8 billion to 3.4 billion in line with the reduced number of locomotives from 112 to 100. I think we've already dealt with that.
Yes.
Then, towards the bottom of the page, the third last paragraph, paragraph 5.6.4.20.3. Sharma, the chairperson of the BA, that should presumably be DC, was comfortable with the business case. However, he requested consideration of other alternatives to the proposed confinement. So was it Mr. Sharma that requested that?
I can't quite recall exactly who it was.
But it could have been him.
Just repeat that.
I can't quite recall exactly who it was.
Oh,
You can't presumably rule out that it was Mr. Sharma.
It could have been.
Then over the page, page 120, the fourth paragraph, paragraph 5.6.4.20.9, Sharma later supported the confinement through CSR and did not raise that confinement would affect competition.
5.6.4.20.
0.9. So he supported the confinement to CSR. Well, presumably he must have, because he was the chairperson of the BADC.
And I would also presume that he was not the only one.
Then if we can go over the page, page 121, paragraph 5.6.5.2, we determined that on 11 October 2013, Singh, Mohammadi, Peter and Garma signed a memorandum of submission to BADC for the approval of acquisition of 100 locomotives through a confinement to Mitsui. We noted that the memorandum was dated 15 October 2013, although it was signed on 11 October 2013. We determined that Molefe did not sign the said memorandum. Do you have any comment on that?
Yeah, I can't recall why I would not have signed it, and perhaps
And then if we can...
because the standard practice is that if I don't approve, I say so, that it is not approved. So if something is brought, I either approve or I don't approve, or as in the case of that memo with Ms. Makato, I say noted or I make a comment. But that I did not even express an opinion or sign at all. I can't recall what the reason was.
Could I take you then, please, to page 123 and to the heading, the BADC of 21 October. Let me draw your attention to the last two paragraphs. Paragraph 5.6.7.2, we determined that the memorandum dated 15 October 2013, as reflected above, was discussed at the BADC meeting on 21 October 2013. Sub 1, well, let me take you to sub 2. Chair Pair sought clarity on the withdrawal of the 100 locomotives submission from the agenda, as the committee had requested it to be tabled due to urgency of the transaction. Do you have any recollection of that?
I can't recall that this was discussed in the formal meeting, and I can't recall who raised it. I do recall something like this, but I remember just thinking that, look, this is not something that we should involve ourselves in, and that we need to decide whether we're going with Mitsui or not, and we have to find reasons why we're not going with Mitsui, if we're not going with Mitsui, and why we would go with CSR. Yeah, I just remember vaguely this allegation, and I can't recall that it was in the formal meeting, so I don't know if it is in the minutes or whether it was raised on the sides of the meeting. But there was, I think, in the township, they call it mahem-hem. There's people just talking about this and not really coming forward properly.
gossip.
Gossip, yes, gossip. Yes, I think you understand gossip now, Chair.
Okay.
It's not even saying here who raised that issue.
Could I then please take you to page 124? At the
Yes.
top, paragraph 5.6.7.2.3. Management represented by Malefe Singh, Peter DeFito and Mosia indicated that upon reflection, they opted to withdraw the matter after considering that when the initiatory confinement was made in 2010, there were press reports alleging that the company Mitsui had entered into a 1.4 billion locomotive procurement secret
So
deal.
where are you reading? Which paragraph?
The first paragraph at the top of page 124.
1 to 4.
So they indicated that they opted to withdraw because after the initial confinement, there were press reports alleging that Mitsui had entered into a 1.4 billion locomotive procurement secret deal that was concluded without being put out to tender, which the then special advisor to the former Deputy President Klante was set to benefit from.
Who said this?
Well, it says management represented by Malefe Singh, Peter DeFito indicated that upon reflection they opted to withdraw because of this.
Well, I was never a part of talking about that secret deal.
Then at paragraph 5.6.7.2.6, during our consultation with Callard, he indicated that on 21 October 2013, Malefe withdrew the 100 locomotives memorandum, correct?
Yes.
And then subparagraph 8 under that, during our consultation with Gama, he confirmed that Malefe withdrew the said memorandum. Gama further indicated that the reason why Malefe did not sign the memorandum of 15 October 2013 was because he had changed his mind and did not want Transnet to confine the acquisition of 100 locomotives through Mitsui.
I cannot comment on that.
Next subparagraph, as reflected above, one of the reasons advanced not to confine through Mitsui was the alleged negative publicity relating to allegations of links between Mitsui and the special advisor to the former deputy president. Any comment on that?
No, I can't comment on that. I can't comment on that.
During our consultation, the next subparagraph, with Gianni, he indicated that the allegation against the special advisor to the former President Klante was never investigated at the time. The motivation to Mitsui was rejected by the BADC. You want to comment on that?
Yes, that is true, that it was never investigated. I'm not aware that there was an investigation into the matter.
In the next subparagraph, in his response to our questions relating to the memorandum of 11 October 2013, Sharma stated that your finding at the BAC meeting of 21 October 2013 deliberated and rejected the submission is incorrect, as the matter did not serve before the committee meeting. The minutes which you are in possession of do not support your finding. Any comment on that?
Well, the minutes would reflect exactly what happened at the meeting.
And then sub 13, 2 paragraphs below that, they say it cannot be a coincidence that the memorandum that Malefe did not sign on 15 October was the same memorandum that the BADC rejected in its meeting of 21 October 2013. It is further not a coincidence that the BADC rejected the confinement through Mitsui, the recommendation to which Malefe did not sign prior to the presentation to BADC. Do you want to comment on that?
Well, yeah, this is now becoming stranger than fiction. So there was a memorandum that I did not sign that nevertheless served before BADC. Is that, I don't know, is that what happened? Because if I had not signed it, it could not have gone to BADC. And if it did, it would have been irregular. And as I've said before, that memorandum was not signed, and it did not indicate whether I disapproved or approved or had reservations I did not give reasons. The normal practice would have been for me to sign, but then indicate, bring the matter to finality one way or another.
All right, and then if I can move on to,
So if it was a memorandum that I had not signed, it is a memorandum that does not exist.
I want to move on to page 126, under
Yes.
the heading Memorandum to Confine through CSR dated 21 January, which we've dealt with. And go to paragraph 5.6.8.10, the second last one on that page. We determined that after Singh received the memorandum from Gama, he either changed it or had it changed from a confinement to Mitsui to a confinement to CSR. This is based on the fact that a confinement of the said document signed by Singh and Malefe on 21 January 2014 and 22 January 2014, respectively, had the name of the entity for confinement changed from Mitsui to CSR.
Yes.
I think you've accepted that.
Once it was determined that we are not going through Mitsui, with Mitsui, as I say, the business case did not change. So the business case for getting 100 locomotives for the coal line was still there. And so the reasons were still the same.
And then the last paragraph on page 126, 5.6.8.11, Gama indicated that the memorandum presented by to BADC by Malefe to confine through CSR did not originate from TFR. Would you take issue with that?
I cannot comment on that.
Well, where did it originate from?
Well, the paragraph before says that it was the same as the Mitsui memorandum.
Yeah.
So the business case for the 100 locomotives
Yes, no, we know that.
did come from TFR.
Yes, but then
So
there was a
as-
change from Mitsui to CSR.
Yes, it was a change in the party,
Yes.
and not in the.
Who affected that change?
I think it was between myself and Mr. Singh.
Yes, well, precisely. It didn't
Yes.
originate from TFR.
No, the origin. Well, maybe
Yes.
we don't understand each other
Well,
because
I think we perhaps do on this occasion.
the memorandum for Mitsui was a motivation for the acquisition
Correct.
of 100 locomotives.
Yes, and that came from TFR.
That came from TFR. In that sense, it originated from TFR.
But what didn't come from TFR was the motivation for confinement to CSR.
Yes.
Correct.
And that is what I'm saying.
Okay. That was done by Mr. Singh and you, as you say.
Yes.
He further stated that he made the said conclusion based on the fact that none of the TFR officials signed it, and further that TFR recommended a confinement through Mitsui and not CSR. I assume there's not an issue there.
Yes.
And
So
then-
now, Mr.
Yes,
I forget your name.
Myburg.
Myburg.
It's late in the day,
Yes.
Mr. Malefe.
Yes. As I say, over the weekend, I got things that jogged my memory, and these are reports from the engineers.
Sure.
At the
Don't
Mitsui-
speak away from the mic.
As I say that I got things that jogged my memory, and these are reports that came from the engineers, that the Mitsui, amongst others, the Mitsui locomotives had been failing. But this was 2013?
14.
14. The tender had been awarded in 2010. And for 14 years, in between, there had been confinement.
4 years, you mean? You said 2010, 2014.
No, it wasn't 2010. It had been for quite a long time.
You said the award was made in 2010.
Yes, I made a
and this
mistake. It was
2014.
before that. It was before 2010. But for quite a number of years, now I can't remember exactly when it was awarded, I can find that out. for quite a number of years, the tender had been awarded quite a long time ago, and in between there had been confinements. Yeah. So there was this issue of entrenched monopoly, number one, and number two, the locomotives had been failing. Yes.
All right, and then if we could go please to page 127, paragraph 5.6.8.12, the top of the page. You'll see there that it recorded that Gama indicated that he found out for the first time that the confinement was changed from Mitsui to CSR when he was at the BADC meeting of 24 January.
Yes, I can't comment on that. That is what Gama says.
And then if you go to page 129, towards the middle of the page, paragraph 5.6.9.3, this is Mr. Gianni, the gentleman you mentioned. According to Gianni, the confinement of the 100 locomotives to CSR was brought to his attention by Singh on 24 January 2014, before their attendance to BADC meeting of the said day. This is Gianni and Singh, Gianni and Gama.
Yeah, I can't comment on that. That is what Gianni says.
Yes.
Yeah, I can't comment on it.
But it's consistent with the fact that you and Mr. Singh were involved in changing the name, as I understand it,
Yes,
late in the day.
yes.
So it's possible that these people didn't know about this.
It's possible, but I can't comment on it. I can't say for sure that that was indeed
But
the
just
case.
so that I understand this, this is Mr. Gama, the CEO of TFR,
Yes.
right? And Mr. Gianni occupies what position at this time?
Well, this is not them saying it.
But what position did Mr. Gianni occupy?
This is not them saying it.
Well, it's recorded as them saying that.
It's who is it? MNS
Yes,
saying that they said so.
yes.
Yes. So I would rather that they come here and say so. So let us wait for their evidence.
All right. Well, I need to, of course, then-
Because this is what MNS says they said.
No, fair enough, Mr. Malefe, that I understand, but you will appreciate that if we had to run that way, the commission would never come to an end. I need to put to you what they found, and we're going to get Mr. Gama here, you know, and we will deal with this.
No, I would rather that I am not accused of things
Fair
in
enough.
the interest of
I'm
time.
not accusing you of anything. I'm
No,
simply
that's-
saying to you,
No, just saying that, well, Mr. Gama was the CEO of TFR and he did not know about it. Now, I must comment on it. As I say, I can't.
Well-
But Mr. Gama will come here and he will have an opportunity
well, let me
to
put
find
the
out
question
exactly what
another way.
happened.
Are you,
If Mr. Gama repeats this and confirms it as true, then it's fine. Then I can come back and answer to it.
are you able to help the chairperson with the question of whether you think Mr. Gama knew about the change before the BADC meeting? Do you know whether he knew yourself?
Well, that is something that would have been internal to Mr. Gama. It's difficult for me
Fair
to
enough.
say. And he is the best person placed to talk about that.
When you changed the business case, you and Mr. Singh, from Mitsui to CSR, did you tell Mr. Singh that he should distribute that business case to Gama and Gianni?
As I say, we have reports here that say that the locomotives were failing.
No, that's not my question, Please, Mr.
Oh, sorry, what was your question?
My question is, when you affected the change, you and Mr. Singh,
Yeah.
to the business case, the name, the party, Mitsui to CSR, did you tell Mr. Singh that he must send that revision, new case, to Gama and
No,
Gianni?
I think there was a discussion. We felt that the fact that we were not going to get the Mitsui locomotives and that the TFR people were unhappy with the Mitsui locomotives would put the market demand strategy at risk. I was explaining yesterday to the chairperson that the funding of the MDS, 70% of it had to come from operations, from improved operations. This exercise would have improved the volumes and operations by injecting 100 locomotives and into the coal line, improving the efficiency of the coal line, and taking the old coal line locomotives and putting them onto the GFB business and improving volumes and generating revenue to fund the MDS. So, in deciding on the confinement, we had to do something that was practical and that could work. The fact that we were going to buy a reconfine to an entrenched monopoly, and when there had been reports that the locomotives are failing, may not have helped our case. So the concern was to move with speed so that we can improve the operations of the business and generate the money that we need for the MDS. The MDS was not just about rail. I see the Commission's concern is just rail. But the MDS included the ports. It included the pipelines. It included a project to manufacture our own locomotive that would be made in South Africa. Not business development, but in technology development at CSIR. So we needed the money desperately to make the MDS a reality. And I remember having this meeting with Mr. Singh and saying, look, we must just decide and move on.
So, do you feel you've answered my question?
Yes.
But my question had nothing to do with that at all.
Oh, did it?
No.
It's been a long day.
What was it about?
It was a very simple question, and that is when you changed the party in the confinement, in the business
Yes.
case, from Mitsui to CSR, you and Singh, did you tell Mr. Singh that he must send that new thing, that new document, to Gianni and Gama? That's
my
all.
answer was, it was a discussion, and I gave you the context.
But when you told us about your discussion now, right at the end, you said you had a discussion with Singh. You never mentioned Gama.
Did you say, when I had a discussion with Singh, did I talk about Gama?
Okay, no, the question was, Mr. Molefe, after you and Mr. Singh had changed the case
Yes,
from Mitsui to CSR,
yes.
did you ask Mr. Singh, instruct Mr. Singh, tell Mr. Singh to share that document with Mr. Gama and whoever else?
Oh,
Yeah, did you do
to
that?
share
or
it
did
with
you,
TFR.
yeah,
No, I can't recall that. I can't recall that we did that.
All right. So then, I've taken you to paragraph 5.6.9.3 at page 129. Let's go to the next paragraph. Gianni further indicated that he wasn't provided with the memorandum to confine to CSR before the BADC meeting held on 24 January.
5.6.9.3.
5.6.9.4, it's just below.
Yes.
It says he wasn't provided with it. And according to Gianni, he had a glimpse of the memorandum confining to CSR after Singh presented it to the BADC.
Yes, I
Any
think
comment
that,
on that?
this is what MNS is saying about Gianni, and I would rather that he comes here and explains.
And then I must then put to you, perhaps finally in that regard, 2 paragraphs below that, 5.6.9.6. Gianni indicated that he was not certain that CSR could manufacture the 19 e-locomotives as required by TFR because they had not supplied the 19 e-locomotives to TFR before.
Chairperson, Gianni would have to come here. And on this one, I'm quite confident that he would disagree with MNS, that this is what he said.
And then 2 last paragraphs, if I may, at page 130, in the middle of the page, paragraph 5.6.9.10. We determined that as per the Procurement Procedures Manual, version 2, October 2013, requirement, the end user, in this case TFR, should be the one motivating the procurement process to be followed, i.e. confinement or tender before the memorandum may be taken to Transnet Group for recommendation to BADC. We determined that Gama and Gianni, as the end users, did not motivate for the confinement of 100 locomotives to CSR. You did. And Mr. Singh did.
Yes.
What is your response to this?
I would rather Gianni and Gama answer when they come here.
Yeah, but
and
this is not a Gama and Gianni thing. You've accepted that you and Singh motivated. The point is
Yes.
that what M&S is saying is that's in breach of the PPM.
Yeah, Chairperson, this may have been an oversight on our side.
An oversight not to include the people from TFR.
On the need for the locomotives had been determined.
Yes.
Yeah.
And then let's go to the last paragraph I want to take you to, 5.6.9.11. We determined that paragraph 15.1.5 of the 2013 PPM states that, quote, the submission for confinement must be fully motivated in writing by the end user and the Operational Division Chief Procurement Officer, TFR, to Operational Division's Main Acquisition Council, AC, and the Operations Division Chief Executive Officer for prior written support of the recommendation to confine. The submission should be submitted on the relevant template under cover of a memo. Any comment on that?
This is the 2013 PPM. Yeah, it may well have said so, but as we discussed earlier, it also said other things.
So you think this may have been an oversight, as you've said?
Come again?
You've said it could have been an oversight, as you put it.
Yeah, it could have been an oversight, but now reading this, if the reliance was on the 2013 PPM, what I'm saying is that M&S is quoting this part of the PPM, but does not quote the sections that we were dealing with earlier of the PPM that allowed for exactly what happened in the end.
If I may just have a moment.
Are you talking about your power?
Yes.
Your power to approve without a recommendation?
Yes, yes.
Okay.
That was in the 2013 PPM, as we discussed earlier.
I thought Mr. Mybeck said Mr. Volming's point in regard to that was that you only had that power in cases where you are dealing with a confidential confinement.
Yes, absolutely.
Yes.
Not just a normal confinement, if I can put it that way.
Yes, yes.
Yeah.
Yeah, and then...
So this one, wasn't this one, is the position that here we were not dealing with a confidential confinement?
Yeah, perhaps, Chairperson, that technicality could be sustained.
Yeah, okay.
Of course, one's dealing here with a high volume or high value contract, massive contract, correct?
Yes.
All right, let's then move on to the procurement of the 1064 locomotives.
Yes,
Thankfully-
Chairperson, I have a request, and my request is that I'm really exhausted.
Yes.
And
No, that's
I don't think that I will
understandable.
do the 1064 justice if we could come back.
Yes. No, that's understandable. Mr. Mybeck?
Well, I assume that Mr. Malefe says he wants to call it a day now. Or does he want to
I
take
think
a
so,
break?
or
Yeah.
wait, I think you said you are already exhausted,
Yes,
so you
yes.
would like that we adjourn.
Yes, Chairperson, especially that last night
Yeah,
I have to
Yeah.
stay up and read the document.
no, I think that's fair enough.
Yeah, I mean, we
Yeah, that's
don't
fair
think
enough.
that's unreasonable at all,
Yeah,
Chairperson.
yeah. Let's talk about what should be the way forward.
So just to perhaps outline what I've still got to deal with.
Yes, yeah.
We must deal with the 1064, which I think will probably take as much time as dealing with 100, an hour or two. Then what we need to deal with are some procedural issues in relation to that. Then we've got to deal with some of the Neotel and T-System contracts, and then a number of miscellaneous issues. And of course, we haven't got yet to witness 1 and 3. So there is quite a bit that still needs to be traversed, I'm afraid.
And would your estimate of time be something like, what, 3 hours or more?
I would certainly try my best to finish Mr. Molefe in the morning session, if we were to start at 10 or 9 by 1 o'clock.
Yeah.
I don't think it can be done realistically faster than that.
No, that's fine. I just wanted to have an idea. Now, subject to both Mr. Molefe's availability and his legal team's availability, and whatever arrangements may exist, would you propose that we continue with him tomorrow morning, or would you propose to go to the next witness, give him a break, and then he comes back? Or?
I would prefer, and I'm in your hands, Chairperson, to finish Mr.
With his
Molefe.
evidence,
As you
yes.
know, with Mr. Garma, there's some flexibility because we
Yes,
have
yeah.
agreed to reduce the issues that will be dealt with.
Yeah,
It may be that we can even confine them
Yeah.
to a greater extent,
yes.
so that we don't disturb the schedule too much.
Yeah. So you would propose that we continue tomorrow morning with Mr. Molefe?
Yes, with your leave,
Yes,
Chairperson.
No, that would be fine from my side. Would that be fine with you, Mr. Molefe?
Yes, I also prefer to finish with Mr.
Yes.
Maibek.
Your legal team is fine as well, I guess.
We are okay tomorrow morning.
You're okay.
What it would also enable us to do is, I mean, the documents, the 4 documents that Mr. Molefe has introduced, it's obviously important
Yes.
that we get the Secretariat to add those formally to the
Yes.
bundle, and they will be paginated and added to all our files, and he can then address them. I don't want it to be seen that we're not giving him opportunity to discuss those documents.
No, that's fine. So let us then adjourn and start at 10 o'clock tomorrow. Okay, all right. We will adjourn now, and then we'll resume tomorrow at 10 o'clock in the morning.
Thank you,
We
Chair.
adjourn.